बाकी निकल को
They have no obligation to arbitration. Law provides for 3, they want 3. I am asking for 1.
Date on the first page on red dates in your
ನೀವೇನಾದ್ರು ಆಡ್ ಮಾಡಿದೀರಾ?
ಅದೇ ಲಾಸ್ಟ್ ಬಂದು ಕೇಳ್ಬಿಟ್ಟು ಇದು ಮಾಡೋಣ.
ಪ್ರಶಾಂತ್ ಅವರೇ ಬನ್ಲೆ ಬನ್ಲೆ ಬನ್ಲೆ. ಹಾ
ಸ್ಕ್ಯಾನ್ ಕೊಡ್ತೀರಾ?
Order, sir.
On ಮಾಡಿಕೊಳ್ಳಿ.
Demolition of the compound wall and saying that it belongs to the panchayat. Actually, the land is not panchayat, belongs to the panchayat. It is a survey number land. They passed a resolution on the same day, my lord, 22/2/2021. On the same day, they will demolish this thing without giving a notice or reasonable opportunity of being heard.
How I can decide whether that land is it belongs to you, belongs to you? These are things which you should go for trial.
That's why my humble submission is power has been vested to the authority, my lord. That power has not been legally exercised
Or
before demolishing the compound wall. My
that can be a ground.
lord. When we see one annexed claim, my lord.
How that can be one of the grounds in the suit.
That's okay. That with regard to the power which has not been properly exercised, you should kindly see the vested power has been misused. You should kindly see the annexed claim, my lord. Several lands have been approved for the demolition of the things, my lord.
Please read your prayer.
Prayer by mandamus for seeking damages, my lord.
How we can decide?
Second prayer, my lord. Second prayer. Direct the respondent number 1 to make a disciplinary inquiry with regard to these matters.
Who
my
is
lord.
the disciplinary authority?
Authority is the government.
Have you requested the government to do that?
That is why, my lord, that is why I filed an application for this and I filed this writ petition seeking these certain things, my lord.
We are taught in the second year of law, a mandamus, a person seeking writ of mandamus has to show that he had demanded and the other side did not respond.
That for that, my lord, I made 7 letters to the government, my lord. And I have the copies of it and I have produced it in the next week of hearing.
Next week, Kodala.
Hearing,
I
my
will
lord.
never do such things at all. Parkali.
This is the, my lord. Annexure K, my lord. The annexure K is the document where the Taluk Panchayat has stated that the survey numbers have been encroached. That can be taken action in the demolition of things, my lord.
But how I should do that? Damages sell ಕೊಡ್ತೀವಿ ಗೊತ್ತು 226 227 ದಲ್ಲಿ damages sell ಕೊಡ್ತೀವಿ ಅಂದ್ರೆ ಫಂಡಮೆಂಟಲ್ ರೈಟ್ಸ್ ವೈಲೇಟ್ ಆದಾಗ ಅವಾಗ ಮಾತ್ರ 226 ನಲ್ಲಿ ಕೊಡಕ್ ಬರ್ತದೆ. ಇದು ಫಂಡಮೆಂಟಲ್ ರೈಟ್ ಆಗಲ್ಲ. ಅದೋ ನಿಮ್ಮ ಬಿಲ್ಡಿಂಗ್ ಇದನ್ನ ಏನಾಗತ್ತಲ್ಲ ಸೂಟ್ ಹಾಕಿ
ಇದರಲ್ಲಿ ನನ್ನ ಸರ್ವೆ ನಂಬರ್ ಈ ಆರ್ಡರ್ ಏನಾದ್ರು ಸ್ಟೇಟ್ ಮಾಡಿದ್ರೆ I don't have any grievance that I can challenge before the authority. Here in this order, my survey number is 948.
Petitioner is knocking at the doors of writ court with the following 2 prayers. Nodama. Prayers A ಮತ್ತು B M. Learned AGA appearing for first respondent on request opposes the petition, contending that when fundamental rights are violated, ordinarily writ courts grant indulgence is true. However, this is not one such case. Yes. And the disputable facts are staring at the court, and therefore no indulgence can be granted. This contention finds support from the text of the prayer in the light of other pleadings of the petitioner. Next paragraph. However, the grievance of the petitioner that there should be some disciplinary action to be taken against respondents 2 and 5 it may be addressed by the first respondent by issuing appropriate direction to the concerned authorities. This has to be done within a reasonable period, as rightly submitted by learned counsel for the petitioner. This court agrees with the same. Next, in the above circumstances, writ petition is disposed of, reserving liberty to the petitioner to litigate in respect of other prayers, other grievances before the civil court. All contentions in that regard are reserved. Petition disposed of.
I request liberty as given with regard to that approaching government.
Oh, yeah, I have given the direction to the government now. Hello. They are directing the first respondent to look into the grievance of the petitioner as to some disciplinary action being taken against. Anyway, you can.
That I will.
Against the erring officials. If petitioner gives an appropriate representation coupled with the minimum evidentiary material. Okay.
Representation.
In representation.
I have the owner of the property.
You have said that khata should not be done.
The sixth respondent is trying to create a document with respect of Kote property and is encroached upon the property of petitioner and also the interference. In this respect, I have made representation to conduct the inquiry.
Just let them kindly issue direction. The short grievance of the petitioner is as to non-consideration of his representations dated 20 September 2021 and 23/11/2021, copies whereof are at Annexures A series. First, the first learned AGA on request appears for respondents 1 and 2 and opposes the petition, contending that the grievances as aired in the representations cannot be addressed, and that the writ remedy coercing addressal is not suitable. First, having so stated, she agrees to instruct her clients to direct the concerned respondents to look into the grievance of the petitioner in accordance with law. First, with the above assurance, writ petition is disposed of. First, only after signally notice to respondents 3, 4, and 5. 3, 4, 5, 6 is dispensed. It hardly needs to be stated that while considering the grievance of the petitioner, the stakeholders, including the 6th respondent, shall be given an opportunity of having their say. First. Next.
Time maybe.
Although difficulty there. Time madlikke. All right. Time for compliance 3 months. Okay.
Requested for fixing the time for consideration on 2 months.
Your representation padi. Not. Yeah.
Mandamus, my lord. The respond number 3 and 6 is the owner of the disputed property, my lord. Without leaving setback and without violation of the sanction plan, my lord, I have given a representation to the respond number 1 and 2, my lord. They have not considered the representation, my lord. Annexure G, my lord.
The short grievance of the petitioner is against non-consideration of his representations. Dated
16/7/2021.
Presentation dated 16/7/2021.
Annexure G, my lord.
At Annexure G, wherein he has aired some complaint with regard to violation of setback regulations. Building bylaws relating to maintaining of setback. First, this complaint is against the neighboring owner of the neighboring site. Owners of the neighboring site, namely respondents 3, 4, and 5 are
3 to 6, my lord.
3 to 6. First one. Next one. Sri Venkat Reddy, Senior Panel Counsel, on request having accepted notice for the respondents 1 and 2, although initially resisted the writ petition, now agrees to instruct his clients to look into the grievance of the petitioner as aired in the subject representation. First one. See the appreciate. Next one. In the above circumstances, the petition is disposed of, directing respondents 1 and 2 to address the grievance of the petitioner as aired in the subject representation within a period of 8 weeks. Petition representation and inform result thereof to the petitioner within an outer limit of 8 weeks. First, it hardly needs to be stated that all the stakeholders, including respondents, the private respondents hearing, shall be given an opportunity of hearing before taking a decision on the said representations. Next paragraph. It is open to the answering respondents to solicit any information or document from the side of the petitioner as are required for due consideration of the representation. However, subject to the rider that in the guise of such solicitation, delay shall not be proved. First off, time for compliance is 8 weeks. Okay. All contentions kept open. ಅವ್ರಿಗೆ 2 sets ಕೊಡ್ಬೇಕು ನೋಡಮ್ಮ, ಅದನ್ನ ಟೈಪ್ ಮಾಡಬೇಡ, ಕೊಟ್ಟು ಬಂದ್ಕೊಂಡು ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಅವ್ರು ಹೇಳಿದ್ಮೇಲೆ ಟೈಪ್ ಮಾಡ.
Short point for consideration is when admittedly there is a dispute with regard to title of a property.
The
Title of the property. Can the municipal authorities conduct survey and change the colors? That's the short point.
based upon survey.
Just on survey. But the issue is this. Petitioner is an institution which was holding some public premises. That public premises eviction act notice was issued and person was evicted from there. Then that eviction order was questioned in the appeal. The compromise happened and the person who eviction said, I will hand over after few years. Just before handing over, third persons have come and said that it belongs to them. The learned judge said it has to be decided by a competent authority. And the competent authority was wrongly given. That order is stayed by this court. Now, when the dispute regarding ownership is yet to be decided,
How that arises, from which document your version is supported? Whether there is a dispute with regard to that which cannot be addressed by the authority. Not every dispute. A dispute which authority cannot address in the framework of law.
kindly see annexure. Kindly see annexure G is the miscellaneous order.
H.
Page number 58. Now in that 58 page number, the Lords will see next page, serial number 10 is a Divakaram. 58, my Lords, what it is order in miscellaneous appeal 18 of 2016.
N.M. Divakara.
Divakara. He along with these persons claims a title over this property and filed this miscellaneous appeal seeking setting aside of an eviction order. First of all, whether we could file.
No, that is irrelevant.
Right.
Where is the dispute? That is relevant for this. Yes. Where is the dispute which what they have done is wrong, you have to establish.
Yes. But the final order. Order is at page 74. The matter is remanded back to respondent number 1. The direction to consider the claim made by the third party appellants.
No, that is stayed, you said.
That is state.
Now you have to show that the exercise which the respondents have done could not have been done. You have to show.
Annexure A, kindly see the annexure A is the impugned order.
This is the Tiluvalike Patra.
ತಿಳುವಳಿಕೆ ಪತ್ರದಲ್ಲಿ ಲಾಸ್ಟ್ ಪೇಜ್ ಮೇಲ್ಕಂಡ ಉಲ್ಲೇಖಗಳಂತೆ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಮೇಲ್ಕಂಡ ಉಲ್ಲೇಖಗಳಂತೆ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಸದರಿ ಸ್ವತ್ತಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಉಭಯತರರ ನಡುವೆ ನಡೆಯುತ್ತಿದ್ದು ಈ ಕಚೇರಿಗೆ ಸದರಿ ಸ್ವತ್ತಿನ ಅಳತೆ ಮಾಡಿ ಸಂಬಂಧವಾಗಿ ಯಾವುದೇ ನಿರ್ದೇಶನ ಇರುವುದಿಲ್ಲ. Even though there is no direction, ಪ್ರಯುಕ್ತ ದಿನಾಂಕ 29/2022 ರಂದು ಬೆಳಗ್ಗೆ 7 ಗಂಟೆಗೆ ಈ ಕಚೇರಿಯಿಂದ ಅಳತೆ ಮಾಡಿ ರದ್ದುಪಡಿಸಿ.
I have read it. You are slow in reading. I have already completed it. One second. What I will do is let them conduct survey, but let them not do that.
They have conducted the survey. Yesterday they conducted the survey. They wanted to demolish our properties. So my request is they should not do anything further to survey and not demolish our properties and interfere with our possessions.
Okay. Emergent notice. The respondent, the first respondent is restrained. First respondent is restrained from demolishing any of the structures in the existing in the subject property till next date of here.
And not to change the khatas.
Where have they said they are
I
changing?
said so. Vishya ದಯವಿಟ್ಟು ನೋಡಿ. ವಿಷಯ.
Vishya, all right. Where is that order nilli?
ಸ್ವತ್ತಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಎಲ್ಲಾ ಮೂಲ ದಾಖಲೆಗಳನ್ನು ಸ್ಥಳದಲ್ಲಿ ಹಾಜರುಪಡಿಸಿ ಅಳತೆ ಸರ್ಕಾರ ಈ ಮೂಲಕ ನೀಡಲಾಗಿದೆ. ಏನಕ್ಕೆ ಕೈನಿಸಿ in the subject matter ಸ್ವತ್ತಿನ ಖಾತೆಯನ್ನು ಪುನಃಸ್ಥಾಪಿಸಿ
of the building structures and status quo shall be maintained with respect to entries in the khata till next date of here.
ಸ್ಟೇಟಸ್ ಕೋ ಅಂದ್ರೆ ಅವ್ರು ಇವತ್ತು ಚೇಂಜ್ ಮಾಡಿ ಅವ್ರದ್ದೇ ಇದೆ ಅಂತ. No changes shall be made to that pursuant to that. So that
if already they have done,
if not done, yesterday is the survey.
The entries in the property record shall not be changed, comma, if already not changed. Okay.
My lords, I appear on behalf of the respondent in this matter, my lords.
Paper publication.
Or it's a Kogi.
Norian Engineering Private Limited.
Yeah, Thurayan
Engineering
Industries.
Private Limited.
Yes, my
Your paper.
lord. The respondent.
3.
Saket Jasani.
Service self-sufficient in terms of substituted mode. Now, Shri
Saket Bisani.
Saket Visani, Learned Counsel, appears for the said respondent. Call this matter after 2 weeks to enable the respondent to file objections, if any, failing which, right to file 1 stands forfeited.
And serve a copy.
Petitioner to serve a copy on the respondent. Okay. Why only after paper publication you are coming before the court? That
My
means
lord, I received instructions yesterday, my lords. We
It's
did
all
not.
right. It's all right, but that will be noted while deciding the matter. Really.
Certainly.
Should not go that way. Yes.
Publication.
Next.
Lords, for the petitioner, I'll request for a week's time, Lords, I will do the needful.
1 week for steps, failing which petition stands rejected. Next. Yes, brother. Weeks. 2 weeks. 4th time. No, I'm dismissing.
We already taken the steps for the last time also. We know the only one address that is written. Then we will go for the substitution.
2 weeks for taking steps by substituted mode of service. 2 weeks, peremptory. If you do not take it, stands dismissed. Okay.
This matter, my lord, the 2 times it has gone, and it appears they have avoided the service of summons. I mean,
You take substituted
I will take it.
service by substituted.
Yes, my lord.
Same order. Yes.
The petitions in this case, go 3 and process and furnish the correct address. The item has been delivered. That is what the website is showing.
Deliver ಆಗಿದೆಯಾ?
Deliver ಅಂತ ತೋರಿಸ್ತಾ ಇದೆ. ಹೈಕೋರ್ಟ್ ವೆಬ್ಸೈಟ್ ಅಲ್ಲಿ ಡೆಲಿವರ್ಡ್ ಅಂತ ತೋರಿಸ್ತಾ ಇದೆ.
ರಿಟರ್ನ್ ಆಗಿದೆಯಾ?
In that case, I will furnish fresh address. ಯಾಕಂದ್ರೆ responded
Steps.
Durga.
Next. Steps within 2 weeks.
3 weeks.
Fresh steps within.
Because 3 weeks. ಯಾಕಂದ್ರೆ responded is Durga.
All right, 3 weeks. Yes.
Yes, great. My lord, I give to the petitioner, seek 2 weeks time to do the.
All right. Next. Peremptory. Yes. For time. Intimation served. Then held sufficient. In view of the postal shara, universal intimation served. All right, they will come. Yes. Next, maintainability. What is this, Raghu? To go there. The petition is disposed of, reserving liberty to institute the same in the jurisdictional, same in the Dharwad bench, in the Dharwad bench of this court. First, all original documents to be immediately returned to the petitioner. Okay. Mic Pixie. Use mic. Remove your mask. Yes. how you converted that area into commercial access? ಅದೆಲ್ಲ ಕೊಡ್ಬೇಕು. ಇಷ್ಟಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟದ್ದು ಬ್ರದರ್. ಇಟ್ ಓನ್ಲಿ ರೇಸ್ ಟು ಕಮರ್ಷಿಯಲ್ ಅಕ್ಸೆಸ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ದಿಸ್ ಪ್ರಾಪರ್ಟಿ. ಆ ರೋಡಿಗೆ ಬರುವಂತದ್ದು ಒಂದು ತೋರಿಸ್ಬೇಕು ಅಷ್ಟೇ. ಫಾರ್ it is less than 1 second. Suppose if that was not converted into commercial access, avaga would you reject? He reject agiddu and avagu reject agtitta yav rule prakara commercial access agidre challenge ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅವರು. ಅದು ಕಮರ್ಷಿಯಲ್ ಆಗಿದ್ದಕ್ಕೆ. ಕರೆಕ್ಟ್. ಕಮರ್ಷಿಯಲ್ ಆಕ್ಸೆಸ್, ಪ್ಲೀಸ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್, he is challenging your decision to treat it as commercial access itself. ಕಮರ್ಷಿಯಲ್ ಆಕ್ಸೆಸ್ ಇರಲಿಲ್ಲ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ, ಅವಾಗ ಏನ್ ಮಾಡ್ತಿದ್ರಿ? It's a area itself.
Nine sites. That's good.
One road to that road, wherever there is a cross section of that road. But he cannot make use of that for the purpose for which he wants.
Already considered. Before the commercial action group, ಮುಂಚೆನೇ building ಕಟ್ಟಿದ್ವಿ, residential building.
He did not file any objection. Now you wanted that change of land use.
Now we have already taken a building plan by of saying that commercial access, the site portion is more than 240 square meters.
But ಇನ್ನೊಂದ್ಸರಿ examine ಮಾಡಿ. You examine whether it is more than, he is saying it is more than 240 square feet.
Less than 240.
Less than 240. If it is less than 240, then you are not entitled to his version. That's what. You are challenging it.
He's constructed a building saying that obtained a license for more than 240 meters. So if authority concern is more than 240 square meters.
That you could have filed an appeal where the statutory authority could have considered all these aspects.
When I question the same before constructing house, they are not furnishing, and also there is no amalgamation and all those things. He gave false information to the authority concerned. What the intersection plan? Then before constructing it,
you are not answering my question at all, unless you have made a Bhishma Pratipya not to answer. Well, I am asking whatever grievance you are making out, that could have been made out in the statutory appeal, because there will be one member from that service side, one judicial member. They will be in a better position to understand which aspect the apex court considered in that famous SP Sampath Kumar versus Union of India.
My submission to Raj in this matter is my Lord, Your Lordship. You obtained a license by a
appealable order idu? Which is that section? ಹನ್ನೆರಡು ವರ್ಷದಲ್ಲಿ ಇಟ್ಕೊಂಡು ನಾವು ಅಪೀಲಿಗೆ ಕಳ್ಸೋದು ಹೆಂಗೆ?
violation of the building plans, rules and other things, he has obtained a license. Then I have questioned for this on sanction with the building plan.
Into. Read. Why I am saying this is, where Apex Court says in SP Sampath Kumar, where an expert body is created with a member from the administration, another from the judiciary, writ court should not interfere. Because the matter relating, it requires expertise in the matter, and judges are not. Judges do not have that expertise. That is the reason why statutory bodies are created for granting redressal to the citizens. You file appeal within 4 weeks, and if appeal is filed, it should be disposed of within 3 months.
After appeal, non question sanctioning the building plan.
Then you challenge.
Sanctioning a building plan.
Please read that section. Appeal section. ಜೋರಾಗಿ ಓದ್ಬೇಕು, ಎಲ್ಲರಿಗೂ ಗೊತ್ತಾಗಬೇಕು, ನಿಮ್ಗೆ ಇಷ್ಟ ಅಲ್ಲ. Any provision for condonation of delay? When that was done and when we have filed the petition after 30 days. The impugned orders were made on?
I filed it on in the month of July 2010.
26, 2009 order. You have filed it up to 1 year, 1 month.
Sanctioning the plan.
That no provision for condonation of delay. It's a statutory policy. After delay, after a particular period of limitation is over, no raking up of the issue at all, like election petition, like suit. That's the policy of the state.
My submission to this point, once the matter was taken up before this honorable court, admitted, and thereafter says that there is an order, you can't say like
no, I am dismissing the writ petition following that constitution bench judgment of the Apex Court, which said once limitation prescribed by the law with no provision for condonation of delay expires, the court shall not grant the remedy. Remedy dies.
But I am not questioning the planning authority distinct. I am questioning only a sanctioning of a plan.
No.
Sanctioning of a plan. But I am not questioning sanctioning of a plan by the authority concerned. Sanctioning of a plan, building plan.
Kindly see the 26, 2009.
Yes, ma'am. I gave several representation. He has not given. Then I challenged this one. Earlier also I filed a petition. Give a petition. They have not sanctioned this thing. Thereafter I filed this petition seeking for a violation of building plan, building license.
Even that is appealable, na?
That is not appealable.
That's sanctioning plan. If
Sanction is not appealable.
what is the position? Read the section. Whether appeal is person party specific, how the section is worded. Generally, they are worded like any person agree. Not third parties. Sir, judgment tomorrow.
Regarding the task of the matter, regarding planning and other things. And the bylaw and building plans.
Now, if bylaw is set aside, the whole building becomes illegal. So there are facts which you have to address because of ILR 1978 Karnataka division bench. You have to go before the civil court for such things. That's my prima facie view. Again, I will look into.
And also, you are not in this matter. You have violated the building plan, revision master plan. This is a debate. See, adjacent owner has the right to question.
ಅದನ್ನ ಇಷ್ಟೊಂದು disputed facts ಎಲ್ಲ ಇದ್ದಾಗ little bit difficult for me. I mean, instead of that, if you agree, I will say that I permit you to file the suit, and the delimitation will not arise because matter was pending before here. I'll keep all contentions open. Pulling down any structure is a serious matter.
Subject to reject the petition, there is an order of this honorable court. Subject to the petition of the state, and subject to reject the petition.
Private respondent ಯಾರು appear ಆಗ್ತಾರೆ?
Subject to reject the petition, admitted the matter.
Last week, I am representing respondent number 7 and 8, my lord.
7 and 8.
Yes, my lord.
Yes, sir. Just say something.
Well,
You have constructed the building subject to outcome of the writ petition.
building constructed much prior to the order passed by this honorable court, my lord. Not only that, entire area has been treated as a access, and without challenging.
Where have you taken up that contention? Where have you taken up that contention that you had put up the building anterior to the petitioner knocking at the doors of this court? Where is your objection? You can't make some statement across the bar and go.
Your lordship may kindly take up 2:30. By 2:30, I will appear before your lordship in person and make submissions.
You could have said it when the matter was being taken up at the evening. You are saying it at this time. I will not. If you see, you should have made this submission.
Yes,
When
please,
the matter was being opened, you are a senior advocate.
please, my lord.
We are just testing the court whether this will lurch this side or that side.
No,
That
my lord.
impression you should never give.
I was on the line, my lord. It was in the meantime I lost the connection. Therefore, once again I appeared on the online, my lord. That's why I requested your lordship to appear before the court personally. That is the problem.
Okay. Come at 2:30. You had some problem.
Please, my lord.
Next.
I appear for petitioner in this case, my lordship. A week time may be granted to comply the office objection, my lordship.
Of the DC. Who appears for the respondent? Any mistake in that?
IA for recalling abatement order to be
Not necessary. Agli. ಬರ್ಕೊಳ್ಳಿ ಅಲ್ಲಿ ಯಾವುದು ಜಸ್ಟಿಸ್ ಹಕೀಂ ಸಾಹೇಬ್ರದ್ದು ಒಂದು ಜಜ್ಮೆಂಟ್ ಇದೆ ನೋಡಿ. Setting aside abatement, separate application is not necessary. Just find out and give it. ಬರ್ಕೊಳ್ಳಿ. Objections on the subject applications, office objections on the subject application being insignificant and not in consonance with the decision of a division bench decision of this court, bracket and Justice Hakim. These are overruled. First, the applications are allowed. Dodama. Standard format have deregulated petitioner to amend the cost title. Are you notice then?
respondent number 2, 42.
Issue emergent notice. Yes. returnable within 2 weeks. Okay, stay, sir.
Obligement.
All.
Okay. Okay, Narayana. We should place each time. Each time.
1 week, peremptory.
Okay,
For the petitioner, the second respondent is the appellate authority. Refused the notice.
Sorry, sir, held sir. Wrong address. Appellate authority. Not necessary. Appellate statutory authority.
Statutory authority, first respondent.
CEO Jilla Panchayat.
Jilla Panchayat. Appeal appellate.
First, Shri MS Devaraju, Learned Panel Council is requested to accept notice for respondent.
Number 2.
Second respond. Petitioner to serve copy of the petition and file acknowledgement. 1, 2, 3. All. Not worry. 1, 2, 3.
Assessing authority 1 and 3. They have been served.
1 and 2 are served. For 3 hours, okay. You copy code here. Petitioner to serve copy of the petition on the panel council and file acknowledgement in the registry within 1 week, failing which petition stands rejected. Next.
Kindly have it on 14th.
No, serve madi.
Date may kindly be fixed as that.
Call this matter after 2 weeks. Okay.
Okay.
Appear for petitioner, my lordship. Kindly 2 weeks time granted, my lordship. Corrected this.
Yes, sir. 2 weeks, finally. Peremptory. Next.
I'm appearing for the petitioner, my lord. I've complied with the office objections, my lord.
You have complied?
Yes, my lord.
Compliance reported. Registry to verify. Is not in panel of BBMP. BBMP. Shri Vachan. Learned Panel Council is requested to accept notice for respondent. 1 Nala. Krishna's name of Mr. Krishna to be removed. Okay.
State of Karnataka represented by BBMP.
ನಾಯಕರೇ ಇದು ರಿಪೇರಿ ಮಾಡಬೇಕು. ರೆಸ್ಪಾಂಡೆಂಟ್ ಡಿಸ್ಕ್ರೈಬ್ ಮಾಡಿದ್ ನೋಡಿ. ಫಸ್ಟ್ ಟೈಮ್ ಐ ಆಮ್ ಸೀಯಿಂಗ್ ಸಚ್ ಡಿಸ್ಕ್ರಿಪ್ಷನ್. ಸ್ಟೇಟ್ ಗವರ್ಮೆಂಟ್ ಆಫ್ ಕರ್ನಾಟಕ ರೆಪ್ರೆಸೆಂಟೆಡ್ ಬೈ ಕಮಿಷನರ್ ಬಿಬಿಎಂಪಿ. ಬಂದು ರಿಪೇರಿ ಮಾಡ್ಬೇಕು. ಬನ್ನಿ.
ಸರಿ ಸರ್.
Registry petitioner to comply with office objections. Complied. Shri Vachan is requested to accept notice for respondent BBMP. ಅಲ್ಲ BBMP ಅಂತ ಮಾಡಬೇಕು.
ಮಾಡ್ತೇನೆ ಸರ್.
Appear for the petitioners council.
Yes.
So it's a written petition for the mandamus directing them to consider my application for release of balance sites. Mr. Ramesh had filed objections on behalf of the respondent. Lord, they say that they have given us a memo of calculation stating that this calculating some penalty according to them. We have have pointed out to him as to why it is not payable. But
last date you had taken time for filing rejoinder. Now filed it. Good. That also is filed. What is the issue here? What is the urgency?
The urgency is, Lord, from 2019, my application for release of sites, I'm a developer. I developed the layout. But what happened was in 2010, there was a sanction of a layout plan was given, and there was a particular developer. That developer, my Lord, fell ill and he could not complete it. Lord, in 2018, I stepped in and Lord, I completed it within that time. And now, my Lord, the balance 40% sites are not being released. And now, my Lord, my application itself is 2019 and not in 2020. Till date, my application is pending consideration.
Application consider what
now the issue that was from my lord's considered that if they don't develop between 2005 and 15, or then they are liable to pay penalty in terms of this particular. So that in terms of that you would have given us calculations then. On this they have to come back and see that they are liable to pay that penalty or not. So now that
I can make my submission.
The entire issue is resolved. That's all the issue.
They are liable to pay penalty.
Yes.
Under
They don't develop their particular project within a period of 5 years.
There is a
They
delay.
agreed to. Please no.
delay in execution of the project, which is the provision of law.
17 of the
Padi. Authority to issue such circular. This will take about 10-15 minutes. Your friends can go for a cup of tea. Yes.
May I make one suggestion? I need an additional work on this because the senior council not at week's time because I had come prepared with this, but senior council then I need more additional this matter not so that I can speak the combination.
For in second week of April. Short point there.
That's all short.
You have to.
Please, I'm bound to consider.
You have to answer any judgment it was held. Okay, very short point.
That's all the point. Whether my calculation is correct or not.
All. Call after call in the second week of second or third week. Other one date. How courts have viewed that circular and how law is developed, jurisprudence is developed on that, you have to bring it. Circular appears to be 2008. 18.
It was a 2014 circular. It was set aside by the Son.
Just look into that. Yes. Okay.
The respondents 5 to 8.
You should have been Sir M. Vishweshwaraya.
That respondents 5 to 8 are the wife and children of respondent number 4. But respondent number 4 is represented by a counsel.
And sufficient one unclaimed ideal. Unclaimed. 568 unclaimed. 568 served. Held sufficient. In view of postal share unclaimed. Where 5
to 8 mirrors 4 is father. 5 to 8 mirrors wife and children of respondent number 4. They are residing in the very same address. Respondent number 4 is represented by counsel.
Respondent 4. 7 again.
7 was he is also the family member of respondent number 4. They are residing in the very same address.
Entry matter there no?
No, it perhaps you have sought for a writ of random as to consider our representation immediately.
Ready?
The respondent wants to change this matter.
You know the representation.
Representation, as we have next area merits to initiate action against merits the neighboring landowner merits. It's at page 8.
In
initiate action under section 21(1) for violation of building sanction plan.
Appear for the respondent. Mohan Kumar.
ಅಲ್ಲಿಂದ ನೀವು ಮಾತಾಡೋದು ನಮ್ಗೆ ಗೊತ್ತಾಗಲ್ಲ, ಆಮೇಲೆ ಜಸ್ಟಿಸ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಅವಾಗ ಕರೋನಾ ಇತ್ತಪ್ಪ, ಅವಾಗ ಏನಂತಂದ್ರೆ ನೆಪ ಹೇಳ್ತಿದ್ರಿ, ಆಲ್ ರೈಟ್. ಯಾವ ಇಲ್ಲಿ ಅವಾಗೆಲ್ಲ ಓಪನ್ ಮಾಡಿ ಕೋರ್ಟ್ ಅನ್ಕೊಂಡು ಸ್ಟ್ರೈಕ್ ಮಾಡಿ, ಈಗ ಕರೋನಾ ಇಲ್ದಾಗ ದೂರ ಇರೋದು ಕೆಲಸ ಹೆಂಗ್ ಮಾಡೋದು? ಲಾಯರ್ ಜಡ್ಜಸ್ ಎಷ್ಟು ತೊಂದರೆ ಆಗತ್ತೆ ಅಂತ ಗೊತ್ತಾಗತ್ತಾ? ಎಲ್ಲ ಪ್ರೆಷರ್ ನಲ್ಲಿ ಇರ್ತೇವೆ ನಾವು. ಆಲ್ ರೈಟ್, ಕಾಲ್ ದಿಸ್ the short grievance of the petitioner is as to amendment to model fast date. Fast date amendment model ba?
Yes, madam. My application has to be rule 10 application.
No, impleading application is allowed. Since persons named in the application as proposed respondents may arguably have some say over the matter. Petitioner has amended the first title in the open court with leave. Amendment. The short grievance of the petitioner is as to non-consideration of the representation dated 28/1/2021. A copy whereof is at Annexure A. First, its contents are as under. Next one. The notice to respondent, the respondents 1, 2, and 3 are represented by their panel counsel, who is not much in a position to assist the court because of his being online, even when courts are wide open. First, be that as it may. The private respondents that are now included are served except respondent number 7, to whom notice need not be served, since they will have an opportunity of opposing the representation when taken up by the answering respondent. First, next paragraph. Having heard the learned counsel for the petitioner and not able to hear what the panel counsel is saying, this court is of a considered opinion that when a complaint is made by the citizen, it is the statutory duty of the answering respondents to grant redressal to the same in accordance with law and in a time-bound manner. First, this having not happened since more than a year, petitioner is justified in knocking at the doors of writ court. First, in the above circumstances, this petition is disposed of, directing the third respondent to consider the subject representation of the petitioner in accordance with law and inform result of such consideration to him within an outer limit of 6 weeks. 6 weeks. Failing which, the third respondent may be required to pay rupees 1,000 per day of each day of delay. Personally. First, all contention. Next, the consideration of the subject representation would happen with the party after notice to the stakeholders, including the respondents' hearings, served and unserved. All contentions are kept up. No cost now.
Petitioner in this case, a week time may be
21. Have sent copy to BBMP. BBMP yaru? Venkat Reddy ಏನಿದೆ?
Kindly annexure E may be seen, impact number 41, where BBMP has served notice for demolition to the petitioner regarding.
ಇದಕ್ಕೆ ನೀವು ಇದನ್ನ ಕೊಡಿ, representative.
We have given objection at annexure F, my lord, stating that I wish to inform you that I have been residing in the house for over 30 years and you maintain the structure very carefully and diligently. This notice that you sent me has been sent to you by your office without an inspection.
You take a decision.
My lord, I have not inspected the premises, my lord. Without
they will take up that. ಅದ್ರ ಮೇಲೆ ತೊಗೊಳ್ಳಿ.
ದಿನಬಂದಿ ಕಿರಿಕಿರಿ ಮಾಡ್ತಾರೆ, demolish ಮಾಡ್ತೀರಿ. Interim stay may be given for the operation.
ಅದ್ರ ಮೇಲೆ ಡಿಸಿಷನ್ ಆಗೋವರೆಗೆ they should not trouble them. Okay? ಆ ಡಿಸಿಷನ್ ಆಗಬೇಕು ಪ್ಲಸ್ 2 weeks ಆಗಬೇಕು. Interim and final disposal ಮಾಡ್ತಾರೆ. ಬರ್ಕೊಳ್ಳಿ. The short grievance of the petitioner is against the impugned notice dated against the notice dated 13/10/2021 issued by the Chayukarinda, the respondents BBMP in terms of Annexure E. In substance, the notice calls upon the petitioner, notice threatens the petitioner of demolishing the structure in question unless suitable safety measures are taken so that the public is not put to life and limb of public are not put to peril. First. Next paragraph. Learned counsel for the petitioner argues that the contents of the said notice are not true and that he has already sent a reply dated 13/10/2020, dated
Where Ravi?
27 or 29 or
25, my lord.
27/10/2021. 21. Semicolon. Despite that, every day the officials of the BBMP are visiting the spot and threatening to pull down the building in question. Next one. Learned senior panel counsel, Mr. Venkat Reddy, appearing for the respondents, submits that the impugn notice has been issued keeping in view the dangerous position of the dilapidated building in question. And now the petitioner has already submitted the reply. And therefore, he would instruct his clients to look into the same and take a decision in accordance with law. This is appreciated. First, in the above circumstances, petition is disposed of, directing the respondents 1 and 2 to consider reply of the petitioner and only then to pass an appropriate final order. Final order in accordance with law. First, the result of such consideration shall be informed to the petitioner as well. First, till 2 weeks lapse from the date such information is conveyed to the petitioner, comma, no precipitatory action would be taken under the impugn notice. Full stop. All contentions are kept out. Yeah, 2 sets ಕೊಡ್ಬೇಕು ಈಗಲೇ ನೋಡಮ್ಮ ಅದು 2 sets ಕೊಟ್ಟು ಅಷ್ಟೇ ಪ್ರಿಂಟ್ ಮಾಡಿ ಇಲ್ಲ ಓಪನ್ ಮಾಡಿ ಇಲ್ಲಿ ಬಂದು ಹೇಳಬೇಕು ಕೊಟ್ಟ ಬಗ್ಗೆ ಕೋರ್ಟ್ ಆಫೀಸರ್ಗೆ ಓಕೆ Joyce. R7. Permission of to R3. Yaru, respondents.
Respondent number 3 is the returning officer, not it is represented by the state.
Returning officer. You are for respondent number 1.
And respondent number 4 and 7 are placed ex parte before the designated court.
Court. So we'll place them ex parte.
And respondent number 6, though was.
One ನಿಮಿಷ. ಯಾರ್ಯಾರನ್ನ ಎಕ್ಸ್ ಪಾರ್ಟಿ ಮಾಡಿದ್ರು
4 and 7. Here it is 5 and 7.
Await notice ಇದೆ.
ಹೌದು ಅಲ್ಲೇ ಎಕ್ಸ್ ಪಾರ್ಟಿ ಆಗಿದೆ.
All right, we have issued notice. No, other judge has issued notice.
No, my lords have issued notice the other day.
Not await ಆಗಿದೆ. Await notice. ಅಲ್ಲೇನು emergent notice through 3. Returning officer ಯಾರು appear ಆಗಿದೆ? Shri, Mr. AGA appears for R3. Okay. Post after service. Next.
Lord, my respectful submission is this, Lord. I'm not being, though I'm the elected candidate, I'm not being permitted to participate in the Gram Panchayat affairs, Lord. The respondent number, on the other hand, her nomination has been rejected. Despite that, my lord, the election petition was filed and it was allowed.
Petition was allowed.
Petition was allowed.
No, allow ಆಗಿದೆ.
My lord, I'm being now in a fix, my lord. I'm not being permitted to appear to participate in Gram Panchayat deliberations. And also, my lord,
Correct. Set aside ಆಗಿದಲ್ಲ ನಿಮ್ದು ಇದು election.
Also,
ಮತ್ತೆ
because of that, but here the respondent number 1 has not even contested in the election.
He not contest.
He has in his nomination papers, my lord, they have given incomplete information. They have not
assume that he has not contested at all. A voter can call the election in question. That is how the law is structured.
My difficulty is that, my lord, the respondent number 2, Tashildar, is now taking actions to issue fresh calendar of events, my lord.
No.
The event that happens, my lord, the whole petition becomes infructuous.
ಅದು calendar of events ಆಗ್ತಕ್ಕೆ ಮೂವ್ ಮಾಡಿ ನಾ ತೊಗೊಂಡ್ಬಿಡ್ತೀನಿ. Okay, next.
I produced manuscript with regard to annexure A and D.
What?
With regard to D and E.
Yes. What is this, brother?
Lord, with regard to cancellation of my site allotted by the Gram Panchayat after 20 years of allotment, on the ground that I have not constructed the house on the site that was allotted. But it was never the condition in the allotment letter. In fact, it is at annexure C.
Rules ನಲ್ಲಿ ಹಂಗಿಲ್ಲ ನೋ
ಇಲ್ಲ
ರೂಲ್ಸ್ ಅಲ್ಲಿ ಇದೆ
ಷರತ್ತುಗಳು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕರೆಕ್ಟ್. ಇನ್ ಅಡಿಷನ್ ಟು ದೀಸ್ ಆರ್ ಇನ್ ಅಡಿಷನ್ ಟು ಸ್ಟ್ಯಾಚ್ಯೂಟರಿ ಷರತ್ತುಗಳು.
There is, to my Lord, there are no such conditions imposed, Lord. It was basically not. It was cancelled in the view that it was allotted. It was somebody else made an application. The respondent number 4 made an application for allotment of site. Therefore, they cancelled my allotment and allotted the same site to the respondent number 4. In fact, I had put up a thatched hut, my lord. The hut is also in existence. I have produced the photographs before this honorable court. Proper house was not constructed, but
this site is granted for what purpose?
Construction of for residential purpose.
Have you put up construction?
I had put our gudusla hakondali.
Gudusla. Construction ಅಂದ್ರೆ ಅದಕ್ಕೆ ಮೀನಿಂಗ್ ಇದೆ. ಅದು ಇದು ಓನ್ಲಿ ಟು ಈ ಹೆಲ್ಮೆಟ್ ಉಪಯೋಗ ಇಲ್ಲ ಹೆಲ್ಮೆಟ್ ಹಾಕೊಳ್ಳಂಗೆ ಪೊಲೀಸರಿಗೆ ಕಣ್ಣು ಎಷ್ಟಕ್ಕೆ ಕಣ್ಣಿಗೆ. ಇಟ್ ಈಸ್ ಗ್ರಾಂಟೆಡ್ ಟು ಯು. ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ದಲ್ಲಿ ಏನ್ ಹೇಳ್ತೀರಿ, ನಮ್ಗೆ ಯಾವುದೇ ಸೈಟ್ ಇಲ್ಲ, ನಾವು ಮನೆ ಕಟ್ಟಬೇಕು, ಮನೆ ಕಟ್ಟಿಗಳಿಗೆ ಒಂದು ಸೈಟ್ ಕೊಟ್ರಿ, ಆ ಸೈಟ್ ಕೊಟ್ಟಿದ್ರು. ಇಲ್ಲಪ್ಪ ಬೇರೆ ಕೊಡ್ತಿದ್ರು ಅವ್ರು. ನೀವು ಅದು ಕೊಟ್ಟ ಮೇಲೆ ಅದನ್ನ ಹಂಗೆ ಇಟ್ಕೊಂಡು ಕೊಡಕ್ ಬರಲ್ಲ ಆನ್ ದ ಗ್ರೌಂಡ್ ದಟ್ ದರ್ ಇಸ್ ನೋ ಕಂಡೀಷನ್ ಸೇಯಿಂಗ್ ದಟ್ ಐ ಶುಡ್ ಪುಟ್ ಅಪ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಂತ.
It's not my there's no condition ಅದಕ್ಕೋಸ್ಕರ ಕಟ್ಟಿಲ್ಲ. There was genuine difficulty.
ಏನಿತ್ತು 20 ವರ್ಷ ಏನಿತ್ತು
ಅವರು ಅಲ್ಲಿ ಗುಡಿಸ್ಲು ಕಟ್ಕೊಂಡು ಗುಡಿಸ್ಲಲ್ಲಿ ಇವಾಗ they were residing in that thatched hut and they
what is their income status? File affidavit. What are they?
I will do that.
Petitioner to file an affidavit disclosing the financial status, financial and proprietorial status of the petitioner. Where have you stated, because what is the reason you have given for 20 years why you have not put up construction?
Lord, I have said in my petition also that I had immediately on allotment, I have put up a hut there. I was residing there. Due to my family exigencies, my lord, this site is in the Sitapura village. Due to my avocation, I had to shift to the next neighboring town called Mudagi. I was residing, therefore I could not construct the house here. Is what I.
What is your occupation?
Lord, private institutionally some clerk or
For 20 years, I do not interfere. Let it go to a deserving. That sites are allotted for building, constructing houses and for residing there. Not for this that way. I am not interfering.
Right.
The very object is that you should put up in application ಆಗಿರುತ್ತೆ. ನಮಗೆ ಸೈಟ್ ಇಲ್ಲ, ಮನೆ ಇಲ್ಲ, ಮನೆ ಕಟ್ಟಿಕೋಬೇಕು, ಕೊಡಿ ಸೈಟ್ ಅಂತ ಆ ಕಾರಣಕ್ಕೆ ಕೊಟ್ಟಿರ್ತಾರಂತ. ಹಂಗಾಗಿ ಐ ವಿಲ್ ನಾಟ್ ಇಂಟರ್ಫಿಯರ್. ಅದು ನೀವು ಮಾಡಿಲ್ಲ, ಹಂಗಾಗಿ ಬೇರೆಯವರಿಗೆ ಕೊಡ್ತಾರೆ ಅಷ್ಟೇ.
Consult with my client regard to the reason for not considering. My instruction is they were residing in the same place.
Instruction ಅಲ್ಲ, ಇಲ್ಲಿ ಹೇಳ್ಬೇಕು ಪಿಟಿಷನ್ ದಲ್ಲಿ. ನಿಮ್ಗೆ so many things he has whispered into your ears. I do not know that. Writ court will see the papers, nothing else. ಇಲ್ಲಿ ಎಲ್ಲರ ಹೇಳ್ಬೇಕಲ್ಲ ಅದು. That I don't agree, brother. I don't want people to retain the site only for escalation purpose and make money out of that. That's not the purpose of allotment of the sites at all. Supreme Court.
Para 3 of the petition. It is submitted that upon obtaining the land certificate from the government, the petitioner got all the revenue records in respect to the scheduled property mutated in his name, and the petitioner was in continuous peaceful possession of the scheduled property from the date of obtaining the land certificate, and was regularly paying taxes in respect of the same.
What is the hut site?
Had even built a small hut.
1 second. Where is that hut? Show me. And what was the tax you were paying for the hut?
The tax paid receipt is at annexure D, my lord, at page number 32, and annexure E, page number 30.
ಇದು ಟ್ಯಾಕ್ಸ್ ಫಾರ್ ಈ ತೆರಿಗೆ ಸೈಟಿಗೆ ಅಂತ ಕೊಟ್ಟಿದ್ಯಾ, ಮನೆ ಕಟ್ಟಿದ್ದು ಕೊಟ್ಟಿದ್ಯಾ? When you had put that site, that structure you have put there, This is for site. ನಿವೇಶನ ತೆರಿಗೆ. Huh? ಅಲ್ಲಿ ನಿಮ್ಮ ಸೂಟ್ ಪ್ಲೇಂಟ್ ಹಾಕಿದಿರಲ್ಲ ಅಲ್ಲಿ ತೋರಿಸಿ, where you have stated that you have already put up a structure there. You have constructed the hut. Hut ಅಂದ್ರೆ ಏನು? ಎಲ್ಲಿದೆ ಫೋಟೋಗ್ರಾಫ್? ಫೋಟೋಗ್ರಾಫ್ ಎಲ್ಲಿದೆ? And what happened to the suit?
Suit is pending.
Not a case for indulgence, brother. I'm dismissing because you have not put up construction. ಅದು ಹಟ್ಟದ್ದು ಪೇಪರ್ ಫೋಟೋ ತೋರಿಸಿ.
Like it is, they have who have removed those structures because
This is what your friend wants to make the court believe, that he has put the this only skeletal. ಇದು ಎಲ್ಲಿ ಮೇಕೆ ಇದನ್ನೆಲ್ಲ ಕತ್ತರಿಸ್ತಾರಲ್ಲ ಅಂತದಿದ್ದಂಗೆ. Where is the hut?
subsequent to filing.
No. Petitioner seeks to lay a challenge to the fee ಬಂದಿದೆಯಲ್ಲ ಪೂರ fee ಬಂದಿದೆ. Emergent notice. Not a case anyway. Don't want to dismiss it now. It's an emergent notice. Okay. Madam, we call that. Fee ಬಂದಂಗೆ ಕಾಣಲ್ಲ ನಿಮಗೆ. Collect fee. Yes. Suppose if you do not remove the structure, 16 structures within the period which we have mentioned 5 months yesterday, then what should happen? Alternate ಕೊಡಬೇಕು. Otherwise, unless there is threat.
I'm sorry, my lord, I am online.
No, I'll make something else because it's your undertaking. If you do not abide by the undertaking, something should fall upon you. Not again going to court. I court ಹೆಂಗ್ ಕೆಲಸ ಮಾಡ್ತೇವೆ ನಮ್ಗೆ ಗೊತ್ತಿದೆ, ನಾವು ಮಾಡೋ ಕೆಲಸ ಏನು. We are not doing any job at all. Court ಅನ್ನೋದು ಏನೇ ಇದೆ. Yesterday, the matter was taken up. Come on, the following order was passed.
Lord, I appear for respondent number 2. I am apologizing, Lord, I am online.
No issue.
Lord, may make
one. ಮೊಬೈಲ್ ಫೋನ್ ನಲ್ಲಿ ಬಂದ್ಕೊಂಡು ನಾವು ಮಾಡಿದ್ರೆ ನಾವು ಹೆಂಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕೇಳೋದು ಹೆಂಗೆ? ಅದಕ್ಕೆ ನಾನು ಅವರಿಗೆ ಹೇಳಿದ್ದೆ ಪ್ಯಾನಲ್ ಕೌನ್ಸಿಲಿಂಗ್. In terms of the said order, the petitioner has filed the affidavit which reads as under. ಅದನ್ನ ಕಲ್ ಔಟ್ ಮಾಡಬೇಕು because some affidavits are changed after I passed the order.
In para 4
The gist of the affidavit is that the petitioner shall pull down all the 16 structures illegally put up within a period of 5 months to be reckoned from yesterday. Yesterday. Since the tenants allegedly occupying the say structure had sought for a period of 3 months in January itself. January ಅಂತ ಏನೋ ಹೇಳಿದ್ರಲ್ಲ ನೀವು.
ಹೌದು, I have got the representation.
January itself. Yes. And they will be getting 5 more months now. No, come on. they shall not come in the way of the structures being pulled down. Being pulled down. First, if they approach any court, this may kindly be kept in view. If they seek redressal at the hands of redressal in judicial process, this may be a ground for denying relief to them. Any relief to them. First. Next paragraph. If the petitioner fails to abide by the undertaking given to the court, the said act would amount to gross contempt of this court. First, that the part, he shall be liable to pay rupees 10,000 for each of the buildings for the delay of every day. Every day. Every day.
May I make one submission, my lord?
Yes.
From March 2020, my lord, he has relocated the entire structure after we have cancelled the door numbers. From March 2020, my lord, nothing, my lord, statutory, no statutory dues are paid. My lord, building license fee is not paid, trade license fee not paid, building tax, all the dues, my lord, let him clear for 2 years, my lord. He's squatting on the property for 2 years, unauthorizedly. From March 2020.
The petitioner shall pay all taxes and levies
and license
fees. And license fees.
Yes.
And license fees. License fees. Within a period of
1 week, my lord, your lordship is.
1 month. 1 month. 1 month.
Till August 2022, my lord, your lordship is. Because he is getting time till 5 months, for 5 months.
Including for the period of 5 months now given.
Yes.
That would accrue for the period till date, that have accrued for the period till now, and 5 months hereafter. First, it is open to the local body, respondent local body, to take all coercive actions, including attachment of petitioner's other properties for recovering the same. Yes.
In the connected matter, I may be permitted to file.
Whatever has been paid shall be given due discount.
Yes.
Whatever is already paid shall be given due discount. First. Yes.
In the connected
licenses, but you have been carrying on the business there. Therefore, you will be liable to pay even for that.
Yes.
You can't run it on public property. You can't misuse the public property. In India, we are governed by rule of law.
It's not public.
Your property, but you have to make the payment in respect of the business which you have run without a license.
License.
For the tax,
License fee kodbekal.
tax I have to pay.
Tax license fee also, because that's how the Justice Balakrishna has held, like that, where you run the business without a license, you are bound to pay license fee with retrospective effect. Yes.
In the connected matter, my lord, I may be permitted to enter appearance, my lord, tomorrow. 53. ಅದು ಎರಡು ಅದರಲ್ಲಿ ನಾನು ಅಪಿಯರೆನ್ಸ್ ಹಾಕಲಿಲ್ಲ ಸೆಕೆಂಡ್ ಡ್ರೆಸ್
ಶ್ರೀ ಅವ್ರು ಹಾಕೊಳ್ಳಿ ಸುಧಾಕರ್ ಪೈ ಅಪಿಯರ್ಸ್ ಫಾರ್ ಸೋ ಇನ್ ಸೊ ಗವರ್ನಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಅವರ ಹೆಸರು ತೋರಿಸ್ಬೇಕು ಎರಡರಲ್ಲಿ
ಗ್ರೇಟ್ಫುಲ್
I appear for the petitioner, my lord. ಅದರಲ್ಲಿ 29/1/2022 ನಲ್ಲಿ the petitioner died. On 3/2 it came and the 14 days time was granted by the trial court. That's why your lordship has dismissed last time.
Yes.
No, steps have not been taken. Now the steps have been taken to bring the LRs on record. It is within time, my lord.
Applications are allowed. No. The order dated 21/3/2022 stands recalled, and consequently, the petition is restored to the board for consideration. First, call this matter tomorrow. ಎಲ್ಲರ ಅಪ್ಲಿಕೇಶನ್ ಸಾಲ್ವ್ ಮಾಡಬೇಕು.
ಹಾಕಿದೀವಿ ಸ್ವಾಮಿ ಎಲ್ಲರ
call this matter next week.
Next week.
Petitioner to amend the cost title in the meanwhile.
Much obliged.
Twenty-six. 26 IFA for respondent 1 and 2.
I filed 3 applications because there is some delay.
Recall ಮಾಡೋಣ WP.
ಒಂದು ರಿಕ್ವೆಸ್ಟ್ ಸ್ವಾಮಿ, ಇಂಥದಕ್ಕೆ ನಾನು ಸಾಮಾನ್ಯವಾಗಿ ಅಪೋಸ್ ಮಾಡೋದಿಲ್ಲ. ಆದ್ರೆ ಇದು ಡಿಸೈನಬಲ್ ಕೋರ್ಟ್ ಗಿವನ್ ಸಫಿಷಿಯಂಟ್ ಟೈಮ್ ಟು ದೆಮ್. ದೇ ಹ್ಯಾವ್ ಕನ್ಸ್ಟ್ರಕ್ಟೆಡ್ ದಿ ಹೌಸ್ ಆನ್ ದಿ ಪಬ್ಲಿಕ್ ರೋಡ್. 2014 ಅಲ್ಲಿ ಜನಗಳು ಒದ್ದಾಡ್ತಾ ಇದ್ದಾರೆ. ಆರ್ಡರ್ ಶೀಟ್ ತಾವು ನೋಡ್ಬಿಟ್ರೆ ಅವ್ರು ಯಾವತ್ತು ಬಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀವಿ ಅಂತ ಬಂದು ರೆಡಿನೇ ಆಗಲಿ.
ಆರ್ಡರ್ ನೆಕ್ಸ್ಟ್ ಡೇಟಿಗೆ ನಾಳೆ ಹಾಕೋತೀನಿ, ನಾಳೆ ಆರ್ಗ್ಯೂ ಮಾಡ್ಬೇಕು. ದಿಸ್ ಇಸ್ ಚಂದನಗೌಡ ಸಾಹೇಬ್ರದ್ದು ಆರ್ಡರ್. ಮೇಡಮ್ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಪೇಮೆಂಟ್ ಮಾಡಿ 5,000 rupees ಟು ದಿ ಅಡ್ವೊಕೇಟ್ಸ್ ವೆಲ್ಫೇರ್ ಫಂಡ್.
ಬೆಂಗಳೂರು ಪ್ರೊಫೆಷನಲ್ ಹಿಂಗೆ ಹೇಳ್ಬೋದು, ಬೆಂಗಳೂರು ಪ್ರೊಫೆಷನಲ್ ವೆಲ್ಫೇರ್ ಫಂಡ್ ಅಂತ. ಅದ್ರೊಳಗೆ ಜಸ್ಟಿಸ್ KR 1 ಲಕ್ಷ ಕೊಟ್ಟರು ಅದು ಸ್ಟಾರ್ಟ್ ಮಾಡಿದಾಗ. ಬೆಂಗಳೂರು ಪ್ರೊಫೆಷನಲ್ ಬೆನಿಫಿಲೆಂಟ್ ಫಂಡ್ ಮೇಲೆ
petitioner application salute order recalled, subject to petitioner paying ₹5,000 to the Bangalore
Professionals Benevolent Fund.
The Bangalore Professionals Benevolent Fund.
Advocate Association building nalide office adu.
ಅಲ್ಲಿ ಅಡ್ವೊಕೇಟ್ಸ್ ಅಸೋಸಿಯೇಷನ್ ಆಫೀಸ್ ನಲ್ಲಿ ಇದೆ ನೋಡಿ, ಇಂತಲ್ಲ ಅಲ್ಲಿ ಪೇ ಮಾಡ್ಬೇಕು. within 1 week. Within 1 week.
A date may be kindly fixed, a date may be pending.
Within 1 week, failing which the recalled order shall revive on itself and petition stands rejected thereby. First, if a payment is made in time, call this matter on 19/4. ಪೇಮೆಂಟ್ ಮಾಡಿ ಮೊದಲು ನೋಡೋಣ, ಪೇಮೆಂಟ್ ಮಾಡ್ಕೊಂಬನ್ನಿ. By learned coordinate judge for non-prosecution, white order dated so and so. Now the applications are moved and affidavit, etc. Yes, brother.
Serial number 27. Now I'm appearing for the petitioner. Yesterday, I filed a rejoinder and also application for amendment of additional prayer because after the records. Yesterday, I filed because my client had a heart attack, and after recovery, he came yesterday for yesterday, and I prepared. And yesterday,
ಇದರಲ್ಲಿ ಒಂದು ಸಮಸ್ಯೆ ಆಗಿದೆ. 2018ರಲ್ಲಿ the corporation implemented the RMP 2015 by proposing 30 meters road by lot. Now 80% of the road is completed. The particular portion where they are seeking is there is a small temple. My lord, in addition to that, they have encroached the public property of 21 meters by putting up of compound wall and obtain the stay order. My lord, ಅವರು ಸ್ಟೇ ತಗೊಳ್ಳಾದ್ರೆ ಒಂದು ತಿಂಗಳಿಗೆ 10 ಲಕ್ಷ ರೂಪಾಯಿ ಅವ್ರ ಪೆನಾಲ್ಟಿ ಪೇಮೆಂಟ್ ಮಾಡಿ ಕೋರ್ಟ್ಗೆ. ಯಾಕೆಂದ್ರೆ ಟೆಂಡರ್ ಕಾಸ್ಟ್ ಸಿಕ್ಕಾಪಟ್ಟೆ ಕಾಸ್ಟ್ ಆಗುತ್ತೆ. ಪಬ್ಲಿಕ್ ವರ್ಕ್ is stopped. Therefore, my lord, kindly put a condition. I encroach portion and let us permit us to build the road, my lord.
Sir, I'm not sorry, brother. I'm not asking any time, because yesterday, because of my client's difficulty, he has met with a heart problem, and the day for yesterday he came and I filed it immediately and served a copy yesterday also. I filed a rejoinder and also filed an application for amendment seeking to quash the notification which they rely.
All on Tuesday. At the request of Tuesday. Tuesday argue madbek.
Much of it.
At the request of petitioners.
Interim order is there, but interim order is there till that time. Interim order may be continued.
Interim order to continue till Tuesday alone.
Yes. Yes.
Tuesday only. Yes.
Yes, much of it.
Dispensation granted. Yes.
Lordship, item 28, I'm appearing for the petitioners. My apologies, the matter was mentioned before your Lordship, and unfortunately, I am not personally present. I would like to present a brief background in the matter. Your Lordship is well aware. This matter was heard in detail, and there was a chamber hearing by your Lordship with regard to the custody of the minor. The matter was referred to All India Institute of Speech and Hearing Institute to ascertain the viability of visitation by the parents. Now, my lord, this application.
Yeah, whether you went to that child psychologist?
Yes, yes.
Another report. You are not allowing the mother, the parents of the child to.
If your Lordship will see the affidavit, it is only one paragraph, any visitation. Your Lordship, there has been 3 visitations, at least 10 times video conferencing has been done. Lord, the facts are being distorted. Unfortunately,
no,
your Lordship permitted videography.
I will not permit you. You have to answer the court question.
Your Lordship.
Okay, it's not a public platform for the speeches. It's all the writ courts, 227, 226 courts. Speech. Now, you were directed to permit the parents of the child to visit the premises, spend time, interact with the child. Did you permit?
Yes. The child did not want to come out. Videograph is there. Your Lordship permitted videography. I would like to present the videographs before your Lordship.
When are you going to put give that videograph?
My Lord, this application has just been listed. Permit me 3-4 days time. I will place the entire facet before your Lordship, because your Lordship had permitted.
This Saturday, Sunday, you go there.
Lordship, may I?
See, this Saturday, Sunday.
May I? Right now, your Lordship, I will just briefly give what has happened. They have visited, the respondents have visited my premise on 4th of December. Thereafter, on 2nd of January. Your Lordship, after that 70 days, there was no connection between the petitioners and the respondents. And thereafter, they have sent a message on 13th of March. They came, they visited. And then after that, there were 2 video conferences. The child does not want to meet. Your Lordship, may I only say, this forceful visitation will only traumatize the child. I am time and again, I've repeated this. The institute has to give a report. Your Lordship may peruse the report and thereafter pass any appropriate order. And I am only trying to say,
Report that child psychiatrist report, where is that?
Lord, it was to be submitted before your Lordship in seal cover. I am sure it must have come to your court because we have not been given a copy. We went to the institute, they refused to give us a copy.
Report dated?
Lord, we have not been told any details.
Secret report. This Saturday, you permit parents to see the child for half an hour.
The child and the grandfather, they are right now in outskirts in Coorg. They are trying to spend some quality time. I may permit, let them come on Monday or Tuesday. I have no issues. No issues.
Monday, all right.
Monday or any.
Monday, what time the parents should come there?
Let them come at 2 lunchtime, whatever. But your Lordship, may I only say, as your Lordship had permitted by the previous order, videography, because the child does not want to meet at all. So let the videography.
Every child will do that way only because child get attached more to people with whom it resides. Anyway, that happens.
Lord, that is why your Lordship permitted.
Mother, you don't want to see
no, Lordship,
mother not being permitted to see the child
because
is something
the mother,
serious, brother.
Mother did not meet the child for 3 years. There was a gap
Solid.
made by the mother. The gap was made by the mother.
Ali, I have spent hours on this case.
Correct, Your Lordship.
As you all know, hours I have
Correct.
spent.
Correct, Your Lordship.
Okay. Therefore, with that background, I am telling you, which you have already agreed that you will permit on Monday.
Yes, yes. Yes, yes.
To which I now Monday, you parents, both husband and the father and mother will go there. I will direct one who is ali resident officer sir ali madam. Your child development officer yaro irbekala CDPO na. The the parents of the child shall be permitted to interact. Parents, respondents anymore. Your the respondent parents shall be permitted to interact with the child in the residence of the petitioners in
Lord, may I say, not at the residence, at Riverview Mayura, because that is where the child is most comfortable. That is where they have been. And that is
Riverview Mayura.
Riverview Mayura.
Come on. That Riverview Mayura Hotel. Hotel. ಏನು ತೊಂದರೆ ಇಲ್ಲ, ಇನ್ನೂ ಚೆನ್ನಾಗಿರುತ್ತೆ. ಇಲ್ಲಿ ಮನೆಯಾದ್ರೆ ಮತ್ತೆಲ್ಲ ಎಜುಕೇಶನ್. Riverview Mayura on Monday.
My Lord may fix a time. I will get the child there at 11, 12, whatever is your lordship's convenience.
The cost of hotel accommodation, if any, shall be borne by the petitioners themselves.
No issue.
First off, the interaction period will be 2 hours. 2 hours. First off, the CDPO of Child Development Project Officer, Child Development Officer. The Child Development Officer, Mysore, Srirangapatna, allu irtara. The jurisdictional Child Development Officer shall facilitate visitation rights. On Monday.
Your lordship may also call for the report by the
carbon
All
copy of this order shall be shared with the counsel for the respondents and with the learned AGA who assisted the court.
Your lordship may also call for the report by the All India.
Report, it appears it has not come. 17th of January by speed post. Sorry, note called. Okay. If report ಕಳಿಸಿದ್ರೆಲ್ಲ ನೋಡ್ಕೋಬೇಕು ಮೊದಲು. It is open to the respondent parents to obtain report of the child psychologist, child psychologist.
Lord, both the parties. Lord, both the parties.
It is open to both the sides to obtain in sealed cover the report of the child psychologist and file before the court on the next date of hearing. Which date you want? Next Friday?
Your lordship may have it on 8th. Lordship may have it on 8th because 8th of April. Yes.
8th.
Deeply obliged, lordship. Deeply obliged.
Yes. Yeah. IA1. What is this IA? For? Yes, forged the document. Which document? Even of your application.
page 100 of the petition, my lord.
This is Dattu's judgment.
My lord, when reading the order, that is produced at page 8, there is an order.
What this order says?
This order pertains to the direction to the letter which is also produced to direction to use their name in the Khata members. There is the verified copy which has been obtained for the order of a promo related to promotion.
Which is the document which they have produced?
Are passed by the sun. Are passed by the sun. Page 100.
100. It's the same writ petition. They are impleted.
Yes, they are impleted.
Bring loading registry original file 30. Sorry, sometimes even after impleading, they will do sometimes. We used to do it later. In the meanwhile, some copies used to be obtained. So there would be two sets of copies, one impleted, another non-impleted. That also used to happen years ago. Let us see. Let's say it's a serious matter. We'll see if we see the document, everything will be more. In the original also.
The order passed in the contents of both the orders. When it is completed, the contents of
different. Orders are different. In this, what the order says?
pertaining to promotion of a it's an education matter. Order which is produced in the name in the Khata.
All right, we call for that. If that is, if your version is true, certainly something will happen.
Correct.
WP 8467 of 1996, 86. It's board of on 16/1/1996. Completed petitioner number 2 ಅಂತಿದೆ.
ಸ್ವಾಮಿ ಅದು ತಳಗಡೆ ಬರೆದಿದ್ದಾರೆ. Impleted petition number 2 ಅಂತ ತಳಗಡೆ ಟೈಪ್ ಆಗಿದೆ. ಇನ್ ಬ್ರಾಕೆಟ್.
ಅವರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರಲ್ಲೂ ಇದೆ. Completed petitioner number 2. Even in your order also it is stated. Anyway, everything will be open if I see the originals. Now we are a bit stricter in such matters. You have seen several properties compromise decree ಮಾಡಿಕೊಳ್ಳೋದು properties ಹೊಡೆದು ಹಾಕೊಂಡ್ಬಿಡೋದು ಯಾರ್ಯಾರ್ದು.
You have committed.
Before I made that order.
Cannot claim like that. Yes, ma'am. Action can be taken also. Such
230. 230.
237.
If something is wrong, then it will be horrible at my hands.
It requires action.
I will not so easily leave.
It requires action.
Action. It will be. I don't know whether the persons responsible will be able to go home and get their medicine also. I may not permit. Yes. Pass over.
My lord, what is that? Yes, ma'am.
I have filed, my name is not shown in the file. I have filed application for information package proposal response number.
The application.
I have filed.
I have 1/22 for impeding is your application. Your own application. Our header torshall no.
Lord, I need to file objections. Objections are ready. I shall file it in the office.
ಕೊಡಿ ಮತ್ತೆ ನೋಡೋಣ ಇದನ್ನ ನೋಡ್ಬೇಡ ಮತ್ತೆ ಬೇರೆ ನೋಟಿಸ್ ಏನಾರ ಹೋಗಕ್ಕಾಗತ್ತನ ಅದಕ್ಕೆ
In the set order, due to mistake to oversight, it was mentioned that it is made clear that any of the concepts put up by the respondent instead of
petitioner.
Now we are constructing building day and night. Within 2 days they will complete the construction by violating the license.
My lord, this may not be correct.
Now they have started with construction without permission.
Lord, that may not be correct. If my lord were to peruse the
impleading ಯಾರನ್ನ ಮಾಡ್ತಾ ಇರೋದು
implead,
who are you?
Panchayat is not, Panchayat is a party.
Who are you?
Number 1 is a social because PTO has not taken any action because violation of license. Hence, I have submitted application under RT Act to grant a certified copy. After going to certified copy, I have submitted complaint to PTO. Thereafter, PTO has acted because PTO has polluted within the preserve and not taken any action. Hence, I have filed this application because I am social worker. Number 1. Application number
What is your occupation? What is that social worker you are doing? Padi. Huh? Agriculture. Where have you stated? What is your financial background, social service? Otherwise, abuse at the hands of RT activists. Supreme Court has said. This affidavit is it's not court proceedings are not like wine that becomes better as the time passes.
Continuously, he would file RTI application, obtain the information, then file cases, and in respect of nearby village, he files a case, and that is still pending. The work is completely stopped. In my objection, I have stated that he is a busybody.
also issued legal to the government of Karnataka and number 8, document number 1.
No, your presence is not required because the body is here.
They are polluted with each other.
Let us see. I'll take your assistance if I need, but I generally doubt such versions anyway. Yes, brother. Where is your license?
Yes, my lord. The first license is at page 18, annexure B. Annexure B. Annexure B may be seen at page 18. That is the typed copy.
Originally.
Original, my lord. I have the original. This was and this was renewed. Can you see this? My God, this was from 26/3/2011 to 25/3/2012. Subsequently, my lord, the annexure D may kindly be.
One ನಿಮಿಷ ಇದೇನಿದು?
That is ಮುಂಚೆ ಕೊಟ್ಟಿರೋದು.
ಏನದು ಅದಕ್ಕೆ?
License for construction.
Construction or renovation?
It's for construction. ರಚನೆಗೆ ಅಂತ ಇದೆ.
ಕಟ್ಟಡ ರಚನೆ.
ರೆಸ್ಟೋರೆಂಟ್ ಕಟ್ಟಡ ಮಂಜೂರು ಮಾಡಲಾದ ನಕ್ಷೆಯನ್ನು
next
ಮುಂಚೆನೂ ಇಲ್ಲಿ ಈ annexure D may kindly be seen at page 23. This is from 8/12/2021 to 7/12/22. My lord,
ಈ ಪರವಾನಿಗೆ ಏನಿದು? ಕಟ್ಟಡ ರಚನೆ.
ಇದು ರೆನೋವೇಷನ್ ಗೆ ಹಾಕಿರೋ ಪರವಾನಿಗೆ. ಈ ಪರವಾನಿಗೆ ಇರುವಾಗ ಇದು ದಿಸ್ ಇಸ್ ಇನ್ ಫೋರ್ಸ್ 8/12/2021 to 7/12/22.
That is for renovation.
Renovation.
That I am not constructing. It's not a new construction. My lord, the business is run in the same place for more than 30 years. I have stated in the petition. And what happened was, my lord, during COVID period, there is a portion of it is used as for liquor shop. My lord, it's a mangrove tiled roof that few persons passed into that, removed the mangrove tiled roof and got into the shop.
And removed the bottles also.
Yes, and highly intoxicated, all that. So that to prevent such action, I wanted to put a RCC roof. RCC roof definitely requires a strengthening of the pillars and all that. I requested for that, and the license was issued to me, and it was renewed.
Where is your application for renewal?
Yes.
Show me what all you wanted to do. Where is your application? ಅದು ನೋಡ್ರಿ ಗೊತ್ತಾಗ್ತದೆ ಎದಕ್ಕೆ ಕೊಟ್ಟಾರೆ ಅಂತ.
Annexure C. ಆಯ್ತು, ಅದನ್ನೇ ನಾನು ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಅಲ್ಲ, ಹೌದು.
But he says that you were hand in glove with the petitioner and
No, they are not taken. That's why I have filed a petition under RT Act. Thereafter, they initiate proceeding. Even after this order.
impleading application is rejected in as much as the I'm passing the take it in as much as the respondent local body has already initiated action by issuing 3 notices. 3 notices. Of course, this was after it was activated by the applicant who seeks impleadment. First off, that makes no difference. And that does not give sufficient locus for seeking impleadment as a party to the petition. First off. However, the applicant may assist the court as an intervener. Petitioner to amend the cause title.
Please,
Document number 4, page number 20, I have produced it.
All right, don't waste now. They are here now. They are looking after. You can assist the court. You cannot be a party. So that you cannot take the matter in appeal. You can assist here. That's all. Yes. Otherwise, Allah, it will do. Yes.
My lord, one submission. Yes, my lord. I will abide by the orders of this honorable court. But before that, would your lordship be kind enough to see annexure K page 33? They extend the license. And during the extended period, because somebody complains, straight away they ask me to stop it. Can you see annexure K at page 33?
ಇದಾದ್ಮೇಲೆ ಏನ್ ಮಾಡಬೇಡಿ ಇವತ್ತಿನಿಂದ ಈಗ ಆಲ್ರೆಡಿ ಮಾಡಿ ಆಗಿದೆ ನೀವು that will be subject to outcome of the petition. Number 1. Anyway, you can file appeal against this order.
Well, that is why
construction ಆಗಿದೆ ಇಲ್ಲ construction ಆಗಿದೆ ಈಗ
construction ಆಗಿದೆ
ಈಗ appeal ಹಾಕೊಳ್ಳಿ ಇದರ ಮೇಲೆ.
What they do is, without any notice, they say that stop it because a right is accrued in me is my respectful submission because the license is issued.
Correct.
The license for cancellation of the license.
If it were to be a money salvage license, these wine shopping ಎಲ್ಲ ಇಲ್ಲಿ ನಡೀತಾ ಇದೆ.
ಅಲ್ಲ, wine shop is the only minus point. There is a grocery shop. There is a grocery shop. And I have been
grocery ತಗೊಂಡ್ರೆ ಎಲ್ಲ ವೈನ್ ತಗೊಂಡೇ ಹೋಗ್ತಾರೆ ಏನು ನೀವು ಹೇಳೋದು ನೋಡಿ.
The days have become like that.
Appeal ಹಾಕೊಳ್ಳಿ. I will permit you to file appeal within 30 days. You take up all anyway, your construction is over now. Even according to you.
My lord, with what happens is
you should not take any precipitory action for a period of 4 weeks. In the meanwhile, let them file appeal. Further construction ಮಾಡಿ.
I am totally crippled with that. For 35 years, I have been doing this.
They are saying that they will not come in the way.
But, my lord, what they do is they inform the electricity authority, don't give connection. My lord, the business has been run for 35 years.
ಈಗ ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಇದೆಯಲ್ಲ ಅದು
ಇಲ್ಲ, ಅದನ್ನು ಕೊಡಬೇಡಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
I know the intent of your client. As a judge, I can see certain things which generally people close their eyes to see. Okay.
Therefore, let there be no disturbance for that matter, because I eke out
The construction agide.
construction is over.
You have applied for electricity.
Yes, my lord.
Electricity body is a party here, not a party.
No, by that time they did not. Now they say that because there is a complaint, we will not supply you with the electricity.
Why should electricity be cut?
Power is required.
All after 2 weeks.
Please.
Have to read. Yes. Next. An amendment. Allah, intervener. Impleading is rejected, but he is permitted to be an intervener, so that he cannot file appeal against this order if it goes against him. Yes. Construction pura agide alla.
That may kindly be taken.
Learned counsel for the petitioner submits that already construction has been accomplished pursuant to the permissions granted, and that no further construction would be put up.
Yes.
First one. Yes, the undertaking is placed on. Yes.
Kindly grant
You will
some
have-
time for complaints.
Yes, Ravi.
Kindly grant some time for complaints.
All right. Dispensation granted. Time 2 weeks. Primary.
So 3 weeks.
3 weeks. All right.
But I have your copy. Petitioner.
Yes, Prince.
Not the petitioner here. He was working as a PDO in a Gram Panchayat called Enmur, Sulyata. From 21/7/2015 to 21/7/2017. Thereafter, he shifted to some other Gram Panchayat. Still now he is working as Gram Panchayat PDO in Punjab, in a Panchayat called Punjab. But during the year from 2016 to 19, some misappropriation of Panchayat funds have taken place. When an inquiry was conducted, my lord, it is in annexure E, my lord, page 23, which your lordship will see. Page 23, my lord. And the inquiry officer found that in the audit, my lord, there was some misappropriation found to the tune of about 8 lakhs.
Yes.
My lord, it was found that 2 employees of the panchayat, one namely my lord Shashikala and another person namely Mohan, both have committed this misappropriation. My lord, thereafter, my lord, these 2 persons were kept under suspension and subsequently dismissed from service. My lord, now, my lord, by annexure L, a caution notice is issued. It's in page 53, my lord. Issued to the petitioner, saying that if he does not make good of the payment of this rupees 8 lakhs, my lord, the prosecution will be initiated against him. My lord, he has not committed any kind of act in this.
You were the supervisor. You are the supervising authority.
He was there from 21/7/2015 to 2017. I would like to point out, your lordship, in annexure E, like during his period, my lord, after his period, in 2019 only, this 2016-17 saal in the 2018-19 saal now.
You were also there.
I was there in the beginning.
That makes no sense. See, we work on the principle of accountability. The government offices work on the principle of accountability.
Please.
If something happens in my chamber, I am responsible. I can't say I was sitting here. I could not see what was happening in my chamber. That will be very feeble defense.
Well, there are different videos during that period. Lord, during my period, my lord, the what was found.
What is the power to recover? Which section empowers you? ಎಚ್ಚರಿಕೆ ನೋಟಿಸ್ ಅಂದ್ರೆ ಕಾಷನ್ ನೋಟಿಸ್.
Caution. And they have not initiated criminal prosecution against those persons who have actually committed the misappropriation. But they are cautioning me that they will initiate a criminal prosecution against me if I do not fulfill the
240 require in writing the production before him of such a person. AB 8. 8. The executive officer may making such as he is any item of expenditure too long. This is notice. Did you file an objection to this notice?
My lord, before that, my lord, there was a notice for which I have filed an appeal to the Jilla Panchayat, my lord, which is in Annexure H, which for which the reply also given by Annexure J.
What happened to appeal?
My lord, may I read?
What happened? ಅದು ಓದೋದಲ್ಲ, ಪೆಂಡಿಂಗ್ ಇದೆ, ಅಲೋ ಆಗಿದೆ, ರಿಜೆಕ್ಟ್ ಆಗಿದೆ.
They have not allowed my appeal. They have stated that ಉಪಯೋಗಿಸಿದ ಮೊತ್ತವನ್ನು ಸಂಬಂಧಪಟ್ಟವರಿಂದ ವಸೂಲು ಮಾಡಿ ಗ್ರಾಮ ಪಂಚಾಯತಿಗೆ ಜಮೆ ಮಾಡಿ ಈ ಕಚೇರಿಗೆ ವರದಿ ಸಲ್ಲಿಸುವಂತೆ ತಮಗೆ ಸೂಚಿಸಿದೆ.
ನೀವು ವಸೂಲು ಮಾಡ್ಕೊಂಡು ಕೊಡಿ.
This was given in 19/2/2020. My lord, I am not the PDO at present, my lord. There is a different person who is a PDO in the place, my lord.
You pay it and file recover that. This is all public money.
My lord,
ಅಂತ ಕೊಟ್ಟಿರ್ತಾರೆ, ಅದೆಲ್ಲ ಜೋಬಿಗೆ ಹಾಕೊಂಡು ನಾವು ಹೋಗ್ಬಿಟ್ರೆ.
My lord, this I would like to also point out Annexure A which I have produced.
That order also you have challenged here. That direction which says you should recover that money and remit it.
But I have not challenged that order. This is very deep. They stated that the caution notice is that I will be prosecuted for the act of somebody else's company. This is what I have challenged.
Correct. Because you have challenged that order. Order challenge ಮಾಡಿದ್ರೆ I would have understood. Maybe that ಇದಂತ ಕಾಷನ್ ನೋಟಿಸ್, ಕಳ್ಳಗೆ ಕಾಷನ್ ನೋಟಿಸ್ ಕೊಟ್ಟು ನೀವು ಕಳುವು ಮಾಡಿದ ಕುಡ್ಸನ್ನು ವಾಪಸ್ ಕೊಡು, ಮತ್ತೆ ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ನಾವು ನಿಮ್ಗೆ ಕಂಪ್ಲೇಂಟ್ ಹಾಕ್ತೀವಿ ಅಂತ ನಾವು ಕಾಷನ್ ನೀಡೆಡ್ ಕಾಷನ್.
I am not the one responsible. There is a finding.
Rightly or wrongly, there is an order against you made by the statutory authority in your appeal. That is not put in challenge. That says that you should remit the money, recover that money, do it. This is how it is structured. ಅದೆಲ್ಲ ಹೇಳೋದು ಬೇಡಾಗಿತ್ತು, ರಿಕವರ್ ಮಾಡೋದು ಬಿಡೋ, ತುಂಬ ದುಡ್ಡು ನಿನ್ನ ಕೈಯಿಂದ ಹೇಳ್ಬೇಕಿತ್ತು ಅವರು.
This notice was not given to me when I was a PDO there.
They have
been the PDO and I was having.
This is the boon in disguise to make use of this. They have given, they should have, they are a little more kinder to you. Though there was no warrant for such kindness. They said, because you have suffered an order. But you prosecute ಮಾಡೋ ಬದ್ಲಿ ಆದೈತೆ ಏನು ಪ್ರಾಸಿಕ್ಯೂಟ್ ಮಾಡೋದು, ಮತ್ತೆ 25 ವರ್ಷ ನಡೀತದ ಕೇಸ್ ಇಂಥ ಜಡ್ಜ್ಗಳು ಎಲ್ಲ. ಹಂಗಾಗಿ ದುಡ್ಡು ಕಟ್ಟಪ್ಪ ಅಂತ ಹೇಳಿದಾಗ ಕ್ಲೈಂಟ್.
The accused, the person who has actually committed this misappropriation, has given confession also, and she filed an appeal before the appropriate authority. That appeal also is rejected.
Your appeal also is rejected.
But, yes, it was actually my letter to the request to the Jilla Panchayat is
public money. Public money. They should not have given all straightway. They should have filed the complaint. Anyway, they wanted to show some concession regarding the way the criminal proceedings are conducted for centuries.
But my lord, I cannot be prosecuted for criminally regarding this case.
That whether you can be prosecuted or not is a matter. When prosecution is launched, there you can take it. How I can say?
Caution notice is directed.
But it is in fact boon in disguise. In one judgment, the Supreme Court said, Justice Kasliwal of Supreme Court said, where a caution notice is given to the employee, saying that if you do not make the repairs, the payments, then we'll launch the prosecution. On that ground, the bail has been granted. I may not be able to lay my hands on that decision. There is such a decision which A.N. Saha in his criminal procedure has quoted that decision. A.N. Saha's famous criminal procedure. It is quoted. Make use of this because I am not interfering. In fact, I may direct them to enforce the order of the appellate authority, which you have not put in challenge.
In fact, it should have been there.
They are very kind to you.
Recovered from through the present video to the persons who have delinquent.
No, that happened in your period. It did not happen.
It's not solely happened. After my period got over,
you
the
are.
entire proceedings have started. That is the reason why I'm
No, you are not. No, you are not correct. 16, 17, you were there.
I was there. 16, 17.
17, 18 also you were there.
Your Lordship,
only thereafter your successor comes. ಅವ್ರು ಏನು ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ ಅವರಿಂದ ರಿಕವರ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ತೀವಿ. ಮಾಡಿದವರು ಮಾಡೋದಿಲ್ಲ.
Can we see annexes E for page 23?
ನೀವು ಅಟ್ಲೀಸ್ಟ್ ಹೇಳಿ ನನ್ನ ಪ್ರಪೋರ್ಷನ್ ಇಷ್ಟಿದೆ, ಇಷ್ಟು ಅಮೌಂಟ್ ಅಂತ ರಿಪ್ಲೈ ಕೊಡಿ.
Here I just point out, my lord, in page 25, the second column. 16-17ನೇ ಸಾಲಿನ ರಸೀದಿಗಳ ಮೂಲಕ ವಸೂಲಿಯಾದ ಜಮೆಯಾದ ನೀರಿನ ತೆರಿಗೆಗಳ ಜಮೆಗಳ ವಿವರ ಕೆಳಗಿನಂತೆ. And ವ್ಯತ್ಯಾಸ is 62,489. So this period was my lord, I left. Okay. Thereafter, my lord, in the next pages, my lord, kindly look at page 28, 17, 18, 17, 18.
ನೀವು ಯಾವ ಡೇಟ್ ಇಂದ ಯಾವ ಡೇಟ್ ವರೆಗೆ ಇದ್ರಿ?
ನಾನು ಇದ್ದಿದ್ದು 21/7/2015 ರಿಂದ 21/7/2017. 2017.
2017 ರಿಂದ
21/7/2017.
ಅಲ್ಲಿ ಎಷ್ಟು ಅಮೌಂಟ್ ಬರ್ತದೆ?
That period, the difference was 62,489 rupees. It is there in page 25. That's in the report. Audit report. 2016-17ನೇ ಸಾಲಿನ ರಸೀದಿಗಳ ಮೂಲಕ ವಸೂಲಿಯಾದ ಮತ್ತು ಜಮೆಯಾದ ನೀರಿನ ತೆರಿಗೆಗಳ ಜಮೆಗಳ ವಿವರ ಕೆಳಗಿನ.
ಎಲ್ಲ ಈ ರೀತಿ ಅಮೌಂಟ್ ಟ್ಯಾಕ್ಸ್ ನೀರಿಗೆಲ್ಲ ಕೊಟ್ಟಿದ್ದನ್ನ ಜೋಬಿಗೆ ಹಾಕೊಂಡು ಹೋಗ್ತಾರೆ. ಲೋಕಲ್ ಬಾಡಿಗಳು ವರ್ಕ್ ಮಾಡೋದಿಲ್ಲ.
After my the Lordship kindly turn to page 28. 2017-18ನೇ ಸಾಲಿನ ರಸೀದಿಗಳ ಮೂಲಕ ವಸೂಲಿಯಾದ ಮತ್ತು ಜಮೆಯಾದ
2,27,501.
2,27,500. I was there till July. Kindly see.
ಏಪ್ರಿಲ್, ಮೇ, ಜೂನ್, ಜುಲೈ ತನಕನೂ ಇದೀರಿ ನೀವು.
ಜುಲೈ ಅಲ್ಲಿವರೆಗೆ ಡಿಫರೆನ್ಸ್ ಇಲ್ಲಿ 24,600 ಇದೆ. ಅದರಲ್ಲಿ 27,000 about 3,000 rupees again. That is ಜೂನ್ ವರೆಗೆ, ಜುಲೈ ವರೆಗೆ ನಾವು ಜುಲೈ 21ನೇ ತಾರೀಕು. ಜುಲೈ 21 ವರೆಗೆ.
ಟೋಟಲ್ ಅಮೌಂಟ್ ಪೇಯಬಲ್ ಎಷ್ಟಿದೆ?
Total amount is 8 lakhs. Total misappropriation is about, I was directed, my lord.
One second. ಅಲ್ಲೇ ಬನ್ನಿ, 28 ಬನ್ನಿ. ಫಸ್ಟ್ ಟೇಬಲ್ ನಲ್ಲಿ 2,27,501 ವ್ಯತ್ಯಾಸ.
ಅದು 2017-18ನೇ ಸಾಲ.
17 ಅಲ್ಲ, ಜುಲೈವರೆಗೆ ನೀವು ಇದ್ದೀರಾ?
ಅದೇ ಜುಲೈವರೆಗೆ ಇರುವಂತದ್ದಿದೆ. ಜುಲೈವರೆಗೆ ಇದು ಬ್ಯಾಂಕಿಗೆ ಜಮೆ ಆಗಿರುವಂತದ್ದು, ದಿನವಹಿಗೆ ಜಮೆ ಆಗಿರುವಂತದ್ದು, ಬ್ಯಾಂಕಿಗೆ ಜಮೆ ಆಗಿರುವಂತ ಡಿಫರೆನ್ಸ್ 4ನೇ ಕಾಲಮ್ ನಂಬರ್ 4 ಅಲ್ಲಿ ಕಾಣಿಸ್ತದೆ.
ಟೋಟಲ್ ಅಮೌಂಟ್ ಪೇಯಬಲ್ ಎಷ್ಟಿದೆ? 8 lakh.
Total, my lord, the total misappropriation that has taken place is about
ಪೂರಾ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಮುಗಿಸ್ದಂಗೆ ಕಾಣ್ತಿಲ್ಲ. 9 ಅಲ್ಲ, ಅವ್ರ ಪೀರಿಯಡ್ ಬರುವಂತದ್ದು ಎಷ್ಟು? ಅವ್ರ ಪೀರಿಯಡ್ ಬಿಟ್ಕೊಂಡಿದೆ. ಬೇರೆ ಬೇರೆ ಹೆಡ್ಸ್ ನಲ್ಲೂ ಮಿಸ್ಅಪ್ರಾಪ್ರಿಯೇಷನ್ ಆಗಿದೆ.
8,72,930 ರೂಪಾಯಿ 60 ಪೈಸೆ.
39
ಡಿವೈಡ್ ಮಾಡಿ ಇನ್ನೊಬ್ಬರಿಗೆ
ನಿಮ್ ಪೀರಿಯಡ್ ಅನ್ನು ಅಪೋರ್ಷನ್ ಮಾಡಿದ್ದಾರೆ. ನಿಮ್ ಪೀರಿಯಡ್ ನಾಗ ಆಗಿದ್ದು ಅಂತ ಅಪೋರ್ಷನ್ Entire amount is 13,66,184. ಅದರಲ್ಲಿ ನಿಮಗೆ ಬರೋದು they have said kindly see brother ನೋಡಿ come to 39 2016-17 ಸಾಲಿನ ಮೊತ್ತ 8,16,91.15 ಅದಕ್ಕೆ ಆಪರೇಷನ್ ಮಾಡಿದ್ದಾರೆ ನಿಮ್ಗೆ.
I was pointing out this the report Varadi Tapasana Varadi. This is what I was pointing out, your lordship, wherein during my period, how much money has been misappropriated? It's been in column number in 6, page number 25, 62,489, and another till July 2017 I was there, where about 3,000 rupees. It's a difference. Total otherly 2,17 ಸಾಲಿನಲ್ಲಿ 2,27,591 ಅದರಲ್ಲಿ ಜುಲೈ ವರೆಗೆ ನಾನಿದೆ. ಜುಲೈಯಲ್ಲಿ 27,372 ರೂಪಾಯಿ.
ಇಲ್ಲ ಸಿಂಪಲ್ ಇರಲ್ಲ, ಬೇರೆ ಬೇರೆ ಆಸ್ಪೆಕ್ಟ್ಸ್ ಇರ್ತಾರೆ. ಆಡಿಟ್ ರಿಪೋರ್ಟ್ ಎಲ್ಲ ಉಪೇಕ್ಷಿಸ್ತಾರೆ.
In fact, it was paid to the bank more. The banking is jame, Dinavahi is jame.
Anyway, now you want relief at the hands of this court, na? Deposit 50,000, 50% of this amount. Otherwise, prosecution start ಆಯ್ತು ಅಂದ್ರೆ just first suspension ಆಗ್ತದೆ. ಅದರ ಬದಲಿ best way is buy some peace by making payment. 50% ಕೊಡಿ.
If I make the money payment, then
no, deposit here. I will say that it will not prejudice your defense in your case in your writ petition.
Not 50%, not some nominal amount, reasonable amount, maybe fixed.
Minimum 50%. Minimum 50%. Otherwise, it should be more actually. Misappropriation, 100% money.
25% would be.
You don't bargain in corruption. A judge does not bargain.
I am, because I am not the one who has committed this.
AG requested to accept notice for first respondent. Jilla Panchayat Mangalore yaridar. AK Vasanta. AK Vasant. Shri AK Vasant. Panel counsel is requested to accept notice for respondents 2, 3 and 4. 2, 3 and 4. Stay of impugned order. Petitioner depositing with the third year of Gram Panchayat another. The fourth respondent Taluka Panchayat, a sum of rupees 2,08,000 within 2 weeks.
One month.
Into such money within 2 weeks. Failing which the state stands vacated on its own. And the respondents can proceed with the initiation of criminal proceedings against the petitioner. First, next one. The deposit shall not cast any aspersion on the petitioner, and that the petition will be heard and decided disregarding the deposit. At least 1 lakh ರೂಪಾಯಿ ಹಾಕೊಳ್ಳಿ. Yes. Yeah. Call after 2 weeks at the request of respondents. Okay. Already appointed.
Agreement to sell, not say partnership was entered into joint development agreement.
You are a successor in interest act.
We are not the party.
Both the sides having argued the matter vociferously for some time, now we agree with the suggestion of this court that there is a prima facie case for appointment of case for arbitration and an arbitrator be appointed. First, Sri Yaran Marti.
Justice,
Since in other connected matters, Honorable Justice A.N. Venugopala Gowda, retired judge of this court, been appointed the arbitrator, the same judge is appointed as arbitrator in these matters too. First, ordered accordingly and petitions are disposed of, keeping open all contentions. All contentions. Yes.
Grateful minutes.
In Venugopala Gowda. The rest of the things follow. Thirty-six. One more week. 2 weeks at the request of the final. Okay, Vivekananda. What appointment. Having argued this petition under Section 11 of the Act seeks appointment of an arbitrator. Thus, after service of notice, respondents having entered appearance through their counsel signify their consent for appointment of the arbitrator. For appointment. First, Yaran Madvik. Stakes estimate.
It is 1 crore.
1 crore odd. All complexity is matterly.
Construction contract.
Construction
When we
contract.
have completed the construction, the amount is to be paid.
ಮಾಡ್ಬೋದಾ? ತೊಳ್ತಾ ಇದ್ದಾರ? Anybody? Ratnakala is taking up arbitration matter. Kuna, Justice Kuna. John Kuna. Standard format. All contentions kept.
There is an arbitration clause, and I also issued a notice proposing the name of the arbitrator to be appointed, for which also they are not responded. There is an outstanding. That is the case.
Objection acting. 2 weeks are melted. 2 weeks. At the request of respondents to file objections, if any, filling which.
Okay. 41.
40 and 41, I appear for the petitioner, my lord.
Wants to file objections.
My lord, this matter came up, my lord, on a month ago, my lord. When I met him outside, he said that there are 3 arbitrators that have been suggested according to the agreement. Can we settle for one? I said, I don't mind.
Next week, Monday, next week.
Lord, what has happened is it is getting postponed only for this, Lord. There is a dispute. Lord, 7 crores are due in terms of rents. They have not paid me rents of 7.
One day week it is. Okay, only 1 week. Call this matter next week to enable counsel for the respondents to file objections if any, failing which try to find one stand for people. Yes.
Both matters, but not 40 and.
Or copy kodi. All. Both matters.
40 and
can
41.
all together.
Yes. See, different floors of the same property, Manoj.
Yes.
The Lordship has passed a peremptory order in the other one also. Very good.
No peremptory order. Next week, yes, in other one also.
Yes. Appealing for the response, but my lord, if you could kindly grant us 10 days to file objections to the petition, my lord. We have filed our wakalat recently. 10 days may be granted.
Objection. Yes, 43. Others need not wait. Come afternoon. This will take some time. 3-4 jana will stay. Next one.
This case, the Lordships directed me to punish the particulars of his property. Your Lordships imposed cost on the respondent petitioner hearing. Out of that, 1 lakh he has deposited. Your Lordships already directed to transfer the same to my account. And so far as the remaining 4 lakhs, your Lordships directed to furnish the particulars of his property. In spite of our best efforts, no such property we could trace it out. Last may kindly.
You appear for whom?
Petitioner from the earlier council. The petitioner has given me the wakalat.
Who is the petitioner? So you don't have to pay. You had troubled that widow for years, defrauded her, which findings I recorded. You made her life miserable. Therefore, I had imposed a cost of rupees 5 lakh on you. And you have English Pratada. Vidava Sri Idrla, Nimatige. Aurigi Mosa, Gagalbaji, Ella Madi, our June 23. Hagagi Nimga 5 lakh rupai.
Instructed him around day. It is well mentioned.
No, I am directing arrested detention. You challenge it.
Only his humble request is that he has sufficiently repented for the misdeeds done by him. So my request is that
where is the application? Where is the repentance?
I thought that because
I am directing his arrest and detention. I will call the police. He has troubled his own sister-in-law, a widowed sister-in-law.
Shown the causes they could not file any application because wakalat is already filed from the earlier course. By submission in that my name is shown, and I may seek the intelligence of the Sovereign Court to scale down or reduce the cost. He is suffering for medical ailments. He requested me for representing on his behalf. So, and moreover, he is having all the difficulties now because he is suffering from.
He should suffer. He should suffer. He made his Babi to suffer for years.
I agree.
Yes. A widowed lady. Mosa Madadu. They can be in jail for a few days. It's a good place for ailing persons also.
He's only sincere apologies.
I am directing his arrest and detention.
Lord, may I request Lord, the
cost maybe because he is a great financial.
He should a criminal upon whom 5 lakh rupees cost is imposed by a considered judgment.
Yes, I have read this.
And he defrauded not some other lady. His own
his own
hit and kin alla. Hit and kin are bare meaning. His own Chikama, who is a Matru Saman, and she is a widowed lady.
Yes.
Then direct the police to take him to the custody immediately. You challenge if it's a bad order, actually. We cannot order their detention immediately. Challenge it, we get ready.
I have advised him sufficiently.
No, that is not, you are not a great scholar to advise him. You have to defend his case. Even advice is not going to give. See, revenge is a wild form of justice. So, law has to show some scope for such revenge. A lady, widowed lady, suffering at the hands of son. Free bidbeka. What is this? Oh, tomorrow nobody will believe the judges. Where is the police? Call police.
Lenience maybe sure. Because he
pay that money. Pay ಮಾಡಿ ಸಮ್ಮಲ್ಲ ಹೊರಗೆ ಬಿಡ್ಲಿಕ್ಕೂ ದುಡ್ಡು ಕೊಡ್ಬೇಕು ಹಂಗಾಗಿ ಆರ್ಡರ್ ಮಾಡಿದ್ದು ಅದಕ್ಕೆ ಹೋಯ್ತು ಈಗ ಒಂದು ಲಕ್ಷ ರೂಪಾಯಿ ಕೊಡಿ ಈಗ ಅದರ್ವೈಸ್ ನಾ ಅರೆಸ್ಟ್ ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ ಇಟ್ ವಿಲ್ ಬಿ ಎ ಬ್ಯಾಡ್ ಆರ್ಡರ್ ಬಟ್ ಐ ವಾಂಟ್ ಟು ಲೇ ಎ ಪ್ರೆಸಿಡೆಂಟ್ ದಟ್ ದಿಸ್ ಶುಡ್ ಹ್ಯಾಪನ್ ಟು ಸಚ್ ಪೀಪಲ್.
That's all.
You have not now you to show bona fide to go out at large. You have to pay money here now. He's inside. He is now in the custody of this court.
That's all.
Where is the application?
I mean, because my vakalat is not shown, that is why I have come up to submit here. Because my vakalat is filed on 17th of March, along with the letter written by the petitioner.
ಅವ್ರಿಗೆ 1 ಲಕ್ಷ ರೂಪಾಯಿ ತಗೊಂಡಾಗಿದ್ದೇನೆ ಈಗ ರಿಲೀಸ್ ಮಾಡಿದಾರಾ?
ನಾವು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟರೆ ಸ್ವಾಮಿ ಇದರಿಂದ ಬಂದಿಲ್ಲ, ಬ್ರಾಂಚ್ ಇಂದ ಬಂದಿಲ್ಲ.
ಯಾಕೆ ಬ್ರಾಂಚ್ ಇಂದ ಹೋಗಿಲ್ಲ ಅಮೌಂಟ್? That man, see the order. ಇಲ್ಲೂ ನಡೀತಾ ಇದೆ ಮೋಸ್ಟ್ಲಿ ರಿಜಿಸ್ಟ್ರಿಯಲ್ಲಿ. Hey, how that man? How that man? He should answer. That money should go to that lady.
Daughter Pallavi and the Rashtra.
Daughter Pallavi.
Adopted
application. ಅದು ಇದನ್ನ ಕೊಟ್ಟಿರಾ ನೀವು ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಟಿರಿ ಡೀಟೇಲ್ಸ್ ಕೊಟ್ಟಿರಾ? ಅದಿಲ್ಲ ಅಂತ ತಪ್ಪು ಮಾಡಿದಾರೆ ಈಗ. ಯಾವತ್ತು ಆರ್ಡರ್ ಆಗಿತ್ತು? ವೆರಿಫೈ ಮಾಡಿ ನಿಮ್ಮ ಕ್ಲೈಂಟ್ ಇಂದ ವಾಟ್ ಶುಡ್ ಬಿ ಡನ್ ಟು ಹಿಮ್? No, I have two options. Two options means one option is legally wrong option, but I want to exercise. The second one is if you say give some more time so that he will come back with money. That option I will accept.
If he pays money to that within reasonable period.
ಅದೇ ಚಿಕ್ಕಮ್ಮ ನಮಸ್ಕಾರ ಮಾಡಿ ಹೋಗಿ ನಂದಲ್ಲ ನಾವು ಆರ್ಡರ್ ಮಾಡಿವಿ ಎಲ್ಲ ಆಗಿದೆ ನಮ್ದೇನು ನಮ್ಗೆ.
He's only seeking intelligence in this court.
No, you want time. You want time now. I'm giving learned counsel Shri.
Time he's requesting at least 1 month's time because he's in a great financial.
Everybody is in nangu lori apply ಮಾಡಿ ಎಲ್ಲರೂ ಗ್ರೇಟ್ ಫೈನಾನ್ಷಿಯಲ್ ಇನ್ಕ್ಲೂಡಿಂಗ್ ಮಲ್ಯ.
He's expressing
ಎಲ್ಲರಿಗೂ ಡಿಫಿಕಲ್ಟಿ ಇದೆ ಗೊತ್ತಿಂದು ಐ ಟೆಲ್ ಯು.
Expressing the difficulty. That's all. Sincere.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ 1 ಲಕ್ಷ ರೂಪಾಯಿ ತಂದು ಕೊಡ್ಬೇಕು. ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅಲ್ಲೇ ಅರೆಸ್ಟ್. ಇಟ್ಸ್ ಬ್ಯಾಡ್ ಆರ್ಡರ್. ಯು ಕ್ಯಾನ್ ಚಾಲೆಂಜ್ ಆಕ್ಚುಲಿ. Law will be settled.
Never advise him to challenge.
No, advise him to challenge also.
Another 2 weeks he will pay 1 lakh.
ಅಲ್ಲೇ ಮೆಮೊ ಹಾಕಿ
Please.
ಕೊಡಿ. Learned counsel name was not reflected in the cause list, having volunteered to appear for the petitioner, files a memo on the instruction of his client present before the court, personally present before the court, undertaking to pay rupees 1 lakh to the respondent Pallavi, Srimati Pallavi, within 1 week, within 2 weeks, as a precondition for he being not arrested by this court, at this moment itself, for disobeying the writ issued earlier. First, request is reluctantly acceded to, and petitioner is given a period of 2 weeks for making payment of another sum of rupees 1 lakh. 1 lakh. The bank account of Srimati Pallavi. Account number kodi, matlab kotilla anta heltaru. The following bank account of Srimati Pallavi. First, the petitioner should report to the Superintendent of Police, Kodagu na? Bola, about the payment on or before Tuesday date. Failing which, the petitioner shall be taken to custody and produced before this court on the next date of hearing. 11th. Weeks from today. 18. This date is chosen by the counsel for the petitioner in the presence of the petitioner himself. Yes. Name of Shri so and so. Delete. Yes. The registry shall send a copy of this order to the Superintendent of Police, Kolar, for information and needful action. Our dating or arrest order we can challenge this. This is a bad order actually. Anyway, my name is show his name also. Yes. Yeah. Yeah.
With my lordship's 3 minutes.
50.
With my lordship's 3 minutes.
Tata is well-regulated case and the road is there in the property. I have blocked the road and my construction is stopped in 2014. 2016, this court directed to produce the original Tata bifurcation records and sanction documents. Still now it is not produced. Application dated 22/9/2005. ಅದು records produce ಮಾಡ್ತಾವೆ direct ಮಾಡಿ
Direction into I filed an affidavit stating that you do not have records. I'll bring it to your lordship and they have it next week.
My lords may direct them the records pertaining to proper Tata bifurcation filed on 22/9/2005 before the Joint Commissioner East. They are deliberately filing affidavits of them. This for 3 directions are there by different judges to produce the original verification.
They do not produce. You know what I will do?
Any date,
Call this matter.
please. Otherwise,
2014 matter. Tuesday. Huh? 8/4. But the respondents are put to notice, put to warning that non-compliance of the orders for production of the documents shall be viewed very seriously, and that may be treated as contempt of this court as well, subject to all just exceptions. 15. Okay. 2018 matter. 19. What is annually?
Court officer. Serial number 42 ಏನಾಯ್ತು?
43, 18/4 sir.
ಅಲ್ಲಲ್ಲ 42 42.
42 weeks sir. Statement of objection file ಮಾಡಿ 10 ತಗೊಂಡಿದ್ದಾರೆ.
Okay.
Court officer, 48 ಏನಾಗಿದೆ?
48 ಇದೆ ಸರ್ 230 ಗೆ.
Okay sir, thank you.
67.
Court officer
67 sir.
Court officer sir. Court officer sir. Court officer. Court officer. Court officer, sir. Sir, serial number 54 ಏನಾಗಿದೆ?
ಅಪ್ಲೋಡ್ ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ, ತೊಗೊಳಲ್ಲ ಅದು. 26 ನೋಡೋದಿಲ್ಲ ಅದು. ಅಪ್ಡೇಟ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಏನ್ ಬೇಡ, ಅಪ್ಲೋಡ್ ನೆಸಿಟಿ ಇಲ್ಲ. ಹೇಳ್ತಾರೆ ಸಾಹೇಬ್ ಕೊಟ್ಟಿಲ್ಲ, ಅದು ಹೇಳ್ತಾರೆ ನಾವು ಮಾಡಿದ್ರೆ ನಮ್ದು ಸಾಹೇಬ್ ಹೊಸ್ಕರದಲ್ಲೇ ಮಾಡಿ ಬಿಸಾಕ್ಬಿಡ್ತಾ ಇದ್ದಾರೆ. ಏನ್ ಬರೀತೀರಾ ಅದನ್ನೇ ಮೇನ್ ಇದ್ರಲ್ಲಿ ಬರ್ಬಿಟ್ಟು ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಹೋಗ್ತಾರೆ. ಪ್ರಪೋಸ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದೆ, ಇದೆಲ್ಲ ಸಿಗ್ತಲ್ಲ ಏನ್ ಮಾಡ್ಬೇಕು? ಆರ್ಡರ್ ಸರಿ ನೀವ್ ಅನ್ಕೊಡ್ತೀರಾ, ನಾ ಏನ್ ಮಾಡ್ತೀನಿ? ನಾನು ಅದೇ ಮಾಡೋದು, ಅಲ್ಲಿ ವೇಟ್ ಮಾಡ್ಬೇಕಾ? ಕೂರ್ಗೆ ಕೆಲಸ ಇರೋ ತರ ಹೇಳ್ತಾರೆ. ಅಪ್ಲಿಕೇಶನ್ ನಮ್ಗೆ ಬೇರೆ ಇದೆಯಾ ಸರ್? ಬೇರೆ
Court officer. Court officer. Court officer. Court officer. Court officer.
Court officer. Court officer. Court officer. Court officer. Court officer.
ಹೇಳಿ ಸರ್ ಏನ್ ಸರ್ ಹಲೋ
ಎಲ್ಲ ಎದ್ದೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ
ಸರ್ ಅದೇ ಎದ್ರು ಒಂದು ಕಾಲಕ್ಕೆ ಎದ್ರು ಏನ್ ಹೇಳಿ ಸರ್
62 ಏನಾಗಿದೆ
62 ಕೇಳ್ತೀವಿ ಸರ್ ನಿಮಿಷ 1 ನಿಮಿಷ ಸರ್
ಇಲ್ಲ 62 ಇನ್ನೂ ರೀಚ್ ಆಗಿಲ್ಲ
62 ಮಧ್ಯಾಹ್ನ ಇದೆ ಸರ್
51 ಸರ್ 51
ಮಧ್ಯಾಹ್ನ ಇದೆ ಸರ್
ಓಕೆ ಏನ್ ಮಹೇಶ್
ಏನ್ ಹೇಳಿ ಸರ್
62 ಏನಾಗಿದೆ
62 ಕೇಳ್ತೀವಿ
ಅದೇ ಹೇಳಿದ್ರಲ್ಲ
1 ನಿಮಿಷ ಸರ್
ರೀಚ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ 62
ಹೌದು
ಮಧ್ಯಾಹ್ನ ಇದೆ ಸರ್ 62 ಮಧ್ಯಾಹ್ನ ಇದೆ ಸರ್
51 ಸರ್ 51
ಪ್ರತಿಧ್ವನಿ ಆಗ್ತೈತೆ ಮಧ್ಯಾಹ್ನ ಇದೆ ಸರ್
ಓಕೆ ಏನ್ ಮಹೇಶ್
ಏನಿಲ್ಲ ಕೊಟ್ರೆ ಹೇಳ್ಬೇಕು ಅದೇ ಹೇಳಿದ್ರಲ್ಲ ರೀಚ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ 62.
Nine, all 2 weeks at the request of.
Serial number 58, my lord.
Next week. Next.
My lord,
No date.
my lord, serial number 67. Could it, my lord, be taken up on Monday, my lord? We are going to withdraw the petition.
57.
67.
Serial number 58, my lordship.
One second.
One minute.
Brother.
My lord.
It has become infectious.
Yes, it will become infectious, my lord. We are going to withdraw so far as first prayer is concerned. But prayer B is concerned, my lord. We are going to start for a liberty. May kindly be, my lord, taken up on Monday, my lord. We are filing the memo along with the signature of the plot. Monday, my lord.
Next week. Okay.
Serial number 58, my lordship.
40.
58, my lordship. See, respondent number 4 died, my lordship. Legal lesson brought on record, my lordship. Kindly 2 weeks time.
Respondent number 4 is stated to have been dead. First steps within 2 weeks.
51ರಲ್ಲಿ
Yes.
ಅಲ್ಲ 51ರಲ್ಲಿ ನಾನು ಸಿನಾಪ್ಸಿಸ್ ಆಗಿ ಎಲ್ಲ ರೆಡಿ ಇದೆ. ಇವತ್ತು ಒಂದು ಸ್ವಲ್ಪ 4 ಗಂಟೆಗೆ ಡಾಕ್ಟರ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಇದೆ.
ಓಕೆ, ಯಾವತ್ತು ಬೇಕು?
ಎನಿ ಡೇ ಕನ್ವೆಂಟ್ ಟು ದಿ ಕೋರ್ಟ್ ಮೇಲೆ ಪರ್ಸನಲ್ ಆಗಿ ಬರ್ತೀನಿ ಈ ಮ್ಯಾಟರ್ ನಲ್ಲಿ.
ನೀವೇನ್ ಪರ್ಸನಲಿ ಬರೋದು ಬೇಡ, ನೀವು ಅಲ್ಲಿಂದಾನೆ ಹೇಳಿ, ನಡೀತದೆ, ಏನ್ ತೊಂದರೆ ಇಲ್ಲ. 51 2 ವೀಕ್ಸ್ ಹಾಕ್ಬೋದಾ?
ಆಗ್ಬೋದು.
ಸಂಜಯ್ ಯಾದವ್
2 weeks.
Public.
All. Pade.
ಸಿದ್ಧಾರ್ಥ ಯಾದವ್ KMP ಮಾಡ್ತಾರೆ.
ಅದು ಪಾಸ್ವರ್ಡ್ ಪಡಿ. Yes. Mr. Siddhartha ji, I will take up your matter maybe after half an hour. You can relax and come back.
Thank you.
Yes. Padi.
Charan?
Yes. License was granted on 2005. Which is that? But J, Swami, J he has not challenged. K he has challenged. 20 June 2009. First prayer. Kindly see first prayer. Page 34. Brother, one second. When the petition was filed, tell me the date of filing of the petition. 7/7/2000. Come to your prayer at page 29, running page 13. Prayer column bunny. See that. That is validity period. When construction of the building was over?
Subsequently, the respondent petition asked. Wherein also we have stated that the section is already taken up. I have also stated in my statement of the effect that the building has been already accepted. And when we have filed an objection statement to this application, we have categorically stated in the statement of
Building is totally how many floors? Only 3 floors. 1 second. It's his version. You may dispute that. The sanction plan is for how many floors? G plus 3. You have put up G plus 3 or G plus 2? G plus 2. Not 4 floors totally.
last 4, when we have filed an application for the injunction, we are putting just fiber columns, steel columns, and fiber sheets. At that time, we filed an application that seeking an injunction not even put steel columns and fiber sheets. We have put up such those sheets and columns just to cover the water tank and other. Just opted out.
In suit, what happened? Still pending. Suit. You are mentioning the suit was filed in the IA was filed in the WP.
As per sanction plan, I have considered that it is final or not in sanction plan. The purpose of the sanction plan is since the building is considered is almost put as a of the 2015 master plan. Only the things remains to regularize this.
No.
Apart from that, so many players have been made in this petition. Of this all regard to this.
Proposition.
Seeking question of building plan sanction and the relinquishment deed executed by the letters in favor of giving of building. And this required inquiry into the facts regarding construction in violation of various documents of different enactments and documents which can be tracked only by a competent school board. Also, this is the case.
What is your explanation for approaching the court with delay? ಅದು ಬೇಡ ಆರ್ಗ್ಯುಮೆಂಟ್ ಬೇಡ ಇಲ್ಲೇ ಹೇಳಿ ಹೇಳ್ಬೇಕು. No, question is not that. Question is, he is pointing out, this order was made on 20 June 2009. You have came to court on 7/7/2010. That is more than nearly about a year, more than a year after. What he says is, within this particular year, I have put all my hard-earned money into this building construction. Entire money he is put. Now, all of a sudden, if you come and you want the court to make an order to pull down the building, well, the latches and delay will come in the way. This is contention. On Matkadi.
Earlier, he started to put up a construction when he has purchased the building in 2004 for non-commercial building. At that juncture, I gave a complaint to the concerned officer. Then he gave an endorsement saying that contrary to the building plan and other things, he has constructed. Then he has stopped the building construction, gave an endorsement to the authorities. Subsequently, and when the commercial access was made by the authority by the revised master plan in the year 2007, thereafter he started to apply for the sanction pending plan. Then 2009 is granted by the sanction pending plan by the authority. Through that the eighth respondent is a joint control of the office of the BDM authority. Is influenced persons granted.
I will not answer it. If you do not want to answer the question, that is another thing. But you have to answer the court's question. 1 day delay may be a delay. This is what Apex Court said in RD Shetty versus International Airport Authority case. 1 day may be a delay. 3 years may not be a delay. Now I am asking. He obtained this license in June 2009. 20 June 2009. License ತೊಂಡಾದ್ಮೇಲೆ ಬ್ಯಾಂಕಿಗೆ ಹೋಗ್ತಾರೆ, ಲೋನ್ ತಗೋತಾರೆ, ಇನ್ವೆಸ್ಟ್ಮೆಂಟ್ ಮಾಡ್ತಾರೆ, ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆಗ್ತದೆ. So much energy is put into that construction. Finance is put.
In April 2010, I gave a complaint to the authority concerned. Annexed P minute, annexed P, page 137.
Annexer P.
Annexed P minute.
But at that time, that impugned order was not there.
2009 is the granted the license.
2010. Annexer?
P minute, annexed P minute.
Page number ಹೇಳಂಗಿಲ್ಲಲ್ಲ.
Page number 137. Annexed P. Request to stop the commercial building on 6. Granted grant. Farmer child purchase the signal was also the penalty transaction in 2020. Ever since he has purchased the site, he has adopted he has paid to he has adopted a clandestine manner and obtained a plan approved on his son Jet's name. Started consistent commercial company. Director of compliance of sanctioned plan purchases of basement road, both contrary bylaws and rules. As stated in bylaw, if the site less than 50 feet by 20 feet, basement road cannot be sanctioned. Likewise, the width of the road is less than 40 feet. Commercial building cannot be sanctioned further under the Electricity Act of Rules. Generator cannot be allowed to install the basement road. Here, the site measurement is less than 58 road, 19 feet road, 27 feet, 30 feet. The assistant director of compliance kindly sanctioned the plan. The site measurement shown is also false. It is not known whether the sanction plan was to favor or personal gain. In any case, this amount should be power and the use of society. Gangana has elaborated the entire site area and removed the earth to the depth of created a big bird. Allah, please resume the site, fill up the site. Kindly share the operations legal sanction plan, even if it detailed report done. And for this, they gave a reflect. You are not getting connection Q.
ನೀವು ಪೇಜ್ ನಂಬರ್ ಹೇಳಲೇಬಾರ್ದು ಅಂತ ಭೀಷ್ಮ ಪ್ರತಿಜ್ಞೆ ಮಾಡಿದ್ರೆ ನಾನು ಅಡ್ಡ ಬರಲ್ಲ.
139 connection Q ಮೇಲೆ ಬನಶಂಕರಿ ಎರಡನೇ ನಿವೇಶನ ಕಟ್ಟಡ ನಿರ್ಮಾಣಕ್ಕೆ ಹೆಚ್ಚುವರಿಯ ಸುಮಾರು 24 ಸದಸ್ಯರು ಮೇಲ್ಗಡೆ ಮುಖ್ಯದಲ್ಲಿ ಒಂದು ಮನೆಯಲ್ಲಿ ಸರಿ ವಾರ್ಡ್ ಸಂಖ್ಯೆ ಅಂತ 13 ನಿವೇಶನ ಅವರಲ್ಲಿ ಮಂಜೂರಾದ ನಕ್ಷತ್ರದ ಪರಿಸ್ಥಿತಿ ತಮ್ಮ ದೂರನ್ನು ನೀಡಿರುತ್ತಾರೆ ಹಾಗೂ ಸದರಿ ನಿವೇಶನ ನಿರ್ಮಿಸುವ ಕಟ್ಟಡ ಸಮಸ್ಯೆ ದೂರನ್ನು ಮತ್ತು ಆಹ್ವಾನ ನೀಡಿರುತ್ತಾರೆ. ಸದರಿ ನಿವೇಶನ ನಿರ್ಮಿಸುವ ಕಟ್ಟಡಕ್ಕೆ ವಸತಿ ಮತ್ತು ವಾಣಿಜ್ಯೋದ್ಯೋಗ ನಕ್ಷೆ ಮಂಜೂರಾಗಿದೆ. ಇದರ ಬಗ್ಗೆ ಮುಂದಕ್ಕೂ ತೆಗೆದುಕೊಳ್ಳಲು ತಮ್ಮ ವ್ಯಾಪ್ತಿಗೆ ಒಳಪಟ್ಟಿರುವುದರಿಂದ ಸದರಿ ಕೋರಿಕೆ ಹಾಗೂ ತೆಗೆದುಕೊಂಡಿರುವ ಕ್ರಮದ ಬಗ್ಗೆ
ಮುಂದೇನಾಯ್ತು?
another authority, Bangalore authority, whether the sanction in favor of the schools ಬದಲಾವಣೆ ಆಗಿದೆಯಾ ಇಲ್ವಾ ಅಂತ ಕೇಳಿದೆ. ಅಥಾರಿಟಿ ಕನ್ಸರ್ನ್ annexure yes, 142 One narrative. ಮನಸ್ಸಿಗೆ ಪ್ರತಿ ಅಧಿವೇಶನ ಸಂಖ್ಯೆ ಉಪಯೋಗ ಬದಲಾವಣೆ ಕುರಿತು ನೀವು ಉಲ್ಲೇಖ ಪತ್ರದ ಅಂಶಗಳ ಬಗ್ಗೆ ರಚಿಸಲಾಯಿತು.
ಅದೆಂತ ಕಂಡಿಲ್ಲ ಅಂತಾರೆ, ಬಟ್ ಇಟ್ ಇಸ್ ದೇರ್ ನೌ. ಅವ್ರು ಏನಾರ ಹೇಳ್ಕೊಳ್ಳಿ, ದೇ ಹ್ಯಾಸ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್ ಇಟ್.
My submission to Lordship in this matter, very early I approached some court as soon as given an endorsement by the authority. They have not taken any action. Even they have given endorsement like this, approach the authority.
When the construction was over, where have you? Where has he stated? Point out.
Wanted to let out the building. I gave a picture.
ಅಲ್ಲಿಲ್ಲ.
That is the first action plan.
ತೋರಿಸಿ ಎಲ್ಲಿಂದ ಹೇಳಿ ತೋರಿಸಿ. ಅಲ್ಲೂ ಇಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾ. Started construction. No, it cannot be 2004 because your sanction plan is of 20 June 2009.
Now sanction building plan is a
No, I am asking, when he completed the construction of this G+3, ಅದ್ರ ಬಗ್ಗೆ ಎಲ್ಲಿ ಹೇಳಿರಿ, ಯಾರು ಹೇಳಿರಿ? To his application. ಅದ್ಯಾವುದು? ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ದಲ್ಲಿ ಏನಂತ ಹೇಳಿದ್ರು? ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆಗ್ತಾ ಇದೆ ಅಂತ ಹೇಳಿದ್ರ, ಮುಗಿದಿದೆ? ಎಲ್ಲಿದೆ ಅದು?
With 26 June 2019, an application filed before the Sample Court. Here is another started third floor, even though there is no sanction building plan. For that, I filed an application before the Sample Court. This Sample Court granted an order of temporary.
But G+3 ಅವರಿಗೆ ಸ್ಯಾಂಕ್ಷನ್ ಆಗಿದೆ. ಗ್ರೌಂಡ್ ಪ್ಲಸ್ 3 ಫ್ಲೋರ್ ಸ್ಯಾಂಕ್ಷನ್ ಆಗಿದೆ. ಯಾವುದು?
Ground floor, first floor, second.
Third floor you have not put up. How many? Who appears for the respondent? Prashant Chandra yaar appear? Niva. How many floors he has put up?
They are not obtained regarding
send your engineer to the spot. Ask him to submit report tomorrow at 11 as to how many floors he has put up, whether there is violation of that. Based upon that, I will decide this matter. Huh? The respondent BBMP is hereby mandated to send its jurisdictional engineer to the building in question with all necessary assistance and instruments, and to report as to whether the private respondent has put up the building in excess of what has been mentioned in the approved building plan and the building license dated 20 June 2009. Anyway, first, this exercise has to be done and report should be filed before 2:30 p.m. tomorrow, failing which the officer may be summoned personally for explaining non-compliance. The necessity for making this direction arose because of assertion of the petitioner that the building has been put up in violation of the building plan, and it's controversial by the owners of the building, respondent owners of the building. Yes. A carbon copy of this order shall be handed to all the advocates appearing in the case. Okay. Yeah, you said that, no? There was some difficulty. No, that I did not know. Anyway, no problem. This is a serious matter because you have to pull down such a huge building where lakhs of money is invested. So court has to be very, very careful in protecting that one. Therefore, I expect, corona ittu, idella ittu, hagagi ನಾವು ಇದು ಮಾಡ್ತಿದ್ವಿ. Now I expect that people should come here and argue unless you are from outside Delhi intaliದ್ರೆ I can't say ಪುಟ್ಟೆಗೆ ಹುಡ್ರೆ ಅವ್ರಿಗೆ ಏನೇನೋ ಸ್ವಲ್ಪ ಸಮಸ್ಯೆ ಇರ್ತದೆ ಹೆಲ್ತ್. No issue. No issue. No issue. Yes. Yeah. Yes. You have to state when loan was applied and sanctioned. Loan sanction paper. The ಹಾಕಿದ್ರಾ ಅದಿದ್ರೆ ಬೇಡ. All. Yes, brother. The original papers. ಬೇರೆ ನಮ್ಗೆ ಇದೆ, ಅದೇ ನಮ್ಗೆ ಇದೆ. ತುಂಬಿಗೆ ಇದು ನೋಡಿ ಒರಿಜಿನಲ್, ಜಸ್ಟ್ ಫೇಸ್ ಇಟ್. ಆ ರೀತಿ ಆರ್ಡರ್ ಇಲ್ಲ ಅಲ್ಲಿ. Certified copy of this order only. It cannot be something else. Order sheet. ಅಲ್ಲಿ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಅಲೋಗೆಲ್ಲ ಆಗಿದ್ದೇನೋ. ಅಲ್ಲ ಅದು ಅಂತ ಇಂಪ್ಲೀಡ್ ಆಗಕ್ಕೆ ಆರ್ಡರ್ ಇದೆ. Assume, presumably, but where is that impediment done in the order? What you have obtained is certified copy of the order. Sit up.
Along with the certified copy, my and also just not that it has been paid on my power of order. That is also I have produced not along with my petition. And
This is the judgment.
kindly see the order sheet. I have also not explained the order sheet. That ABCDEF property has been mentioned in the order sheet.
ABCD?
I asked them to fill the certificate.
But how certified copy can be of this judgment, nothing else. There may be order for impleading, etc., introducing something to the petition, very well, but that has not been done. How is that you got that order?
And what I have asked them to bring the order sheet also. It's also certified copy with them order sheet.
Anyway, brother, now
That not that including allowing application, whether it has been amended or not.
that is the question. That has not been reflected in the order. Where from you got this order? No, unless you say.
I am very bad not because not I have just I am not saying that from message to them. In turn, not they have said that not in the order sheet also is they said. And not how they have obtained their order and who has brought this order and all from them.
Oh, it's a serious matter.
Yes, I understood. And moreover, not this document we have produced only to show that not it is a
One question is not that. If suppose if a forgery of the document takes place, there cannot be defense that I have not put the forged document to use at all. It is like saying, ನಾನು ಬರೀ ಕೋಟಾ ನೋಟ್ ಮಾಡೀನಿ ಅವ್ನ ಸರ್ಕ್ಯುಲೇಷನ್ಗೆ ಹಾಕಿಲ್ಲ ಅಂತ. ಆ ನೋಟ್ ಕೋಟಾ ಮಾಡೋದೇ ಅಫೆನ್ಸ್ ಪರ್ ಸೆ. ಹಂಗಾಗಿ ಅದು ವಾಟ್ ಫಾರ್ ಯು ಹ್ಯಾವ್ ಯೂಸ್ಡ್ ಇಟ್ ಇಸ್ ಇಮ್ಮೆಟೀರಿಯಲ್. ಈವನ್ ಇಫ್ ಯು ಹ್ಯಾವ್ ಕೆಪ್ಟ್ ಇಟ್ ಒಂದು ಕಡ್ಡಿಪೆಟ್ಟಿಗೆಯಲ್ಲಿ ಇಟ್ಟರು ಅದೊಂದು ಅಫೆನ್ಸೇ. About any contents, is there any? Read. Let us. Petitioner who is as reader. Even contents are different.
Totally different. I have also.
Oh.
The contents of that petition are completely different from what we have produced. But not the order sheet, not the speaks otherwise. What my lordship is said, not the as per the amended, whether the amendment has been taken place.
Irrespective of that, the very contents of the order are different from the one in which what are produced in your petition. How can there be such orders? One we had two certified copies of different orders in the same writ petition. That is the only precedent which we have from some Madras judge here. But such things never happened with our judges.
Instruction I placed not two judgments before them. I am telling that not who has got all this now.
And this order is same day, same petition. There are two orders. Only one instance in our High Court, to the bad glory, ignominy of our High Court, there was one judge who had signed two orders contradictory to each other in the same petition, same day. Except that such things never happened in our court. Our court has still got some reputation. This is a serious matter. You have to answer, brother. I may direct COD investigation into this. It's a serious matter. No, I am not against you. Whatever they will produce, you produce Martira. I can't say anything against the lawyers. How they will know? Certified copy, if somebody gives, I also maybe I would have filed the petition. So I can't find fault with counsel at all. How he will know? If this has happened, a person who wants to defraud the court will defraud the lawyer also. No, I don't say for a moment now, immediately that is case of forgery or etc. But I want to have version of your client. But this will not go that easily. This much I will say. I will not leave things to go that easily. But no, contents are totally different. Language also appears to be different. Petitioner has produced a copy, a photostat copy of the judgment. The certified copy alli ಇದೆ. Photostat ಅಲ್ಲ ಇದರಲ್ಲಿ ಜೆರಾಕ್ಸ್ ಇದೆ ಅಷ್ಟೇ. ಇದು certified copy. Who has applied and taken this copy? ನಮ್ಮಲ್ಲಿ ಯಾರು ಅಪ್ಲೈ ಮಾಡಿದ್ರು ಯಾರು ತಗೊಂಡ್ರು ಅನ್ನೋ ಬಗ್ಗೆ ರಿಜಿಸ್ಟರ್ ಇರುತ್ತಲ್ಲ ಇರುತ್ತೆ. Who applied and who obtained?
It will be mentioned in the corner mirror. First page mention ಮಾಡ್ತಾರೆ.
Correct. Petitioner has produced a photostat copy of the judgment dated 16/1/1996 rendered by Honorable Justice H.L. Dattu, as his lordship then was, disposing of WP number 8467/1986. First off, said judgment 86 between Srimati K. Aravinda and two others and one another and another Muniyappa. First off, the said judgment runs into 7 pages. First off, the contesting respondent number 5 has filed the statement of objections. Application has filed application in IA number 1 of 2022 for vacating the interim order, seeking an order for the prosecution of the petitioner for producing a forged, alleging that the said judgment is a fabricated one. But first of all, in support of this submission, the said respondent has produced a certified copy of the judgment dated 16/1/1996 rendered by Honorable Justice so-and-so, whereby the very same case, that is writ petition number 8467 of 1986, was disposed of. First off, in terms of cost title and content, perhaps effect 2, there is a marked variance between these two judgments purportedly rendered by the same judge in the very same case. Full stop. Next paragraph. To prima facie ascertain the authenticity of one of them, registry was directed to and accordingly has produced the original file in WP 8467 of 1986. With the original order. Judgment. No, this is not. No, this is a court of record. Petition ella ಮಾಡ್ತಾರೆ. Order has to be maintained for eternity. Original ಎಲ್ಲಿದೆ?
What does autograph?
Original ಬೇಕಲ್ಲ, original has to be maintained. It's a court of record. Very rare. It's a serious matter. Something appears to be amiss, to say the least. The original record does not contain autographed judgment. Occasionally, original judgment. Original judgment. First of all, High Court is a court of record, and its judgments and orders are reserved for eternity. Although the pleadings and other documents may be consigned to the dustbin of time. First of all, something appears to be amiss, and it warrants a thorough investigation. Presently, a thorough in-house investigation. Presently, that may eventually lead to a COD or CBI inquiry. First one. Next one. In the above circumstances, the Registrar General of this court is directed to conduct inquiry and investigation into the matter and submit a report in a sealed cover within no, I'm not against you. I'm saying whoever has done that. Question is, you may succeed in the writ petition also. That is another thing. But suppose if you have put something which is not there, means your client, for that there will be action. It's independent of that. That's a two different thing. You may not bank upon this document at all, but that is no defense where document is forged one or fabricated one. The report shall be submitted within 1 week. First. If more time is required, request may be made. The Registrar General to keep the original file in his exclusive custody. First, original file is sent back. Yes, send back the original. Yes, okay. Something grave will happen. This appears to be serious matter. Even the language usually there, because we used to appear before Honorable Justice very often, because he was sitting for service matter for 1 year. So the language is different. That's all right. That there is a direction is also. I doubt that also now. Anyway, I can't say anything more than that now at this stage because the inquiry will be this one. Okay. All right. This I have to look in. No, it's a serious matter. Anyway. ಅಲ್ಲ ಅವ್ರಿಗೆ ಕೊಟ್ಬಿಡಿ ಇವ್ರಿಗೆ ಹೌದು ಇದು ಬಂದಿದೆ ಅದು ಒರಿಜಿನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ಲ ಒರಿಜಿನಲ್ ಇಲ್ಲ ಎಸ್ ಲೆಟ್ ಅಸ್ ಸಿ Rowdy sheeter will take 10-15 minutes. Everything is over now. You were supposed to say, you said other day, they only four complaints are before the police complaints authority. How long they have been pending and what is going to happen? Last 29 years. That ended in the acquittal long ago. Original copy kodbek.
Prior to that, fellows, one aspect court wanted me to ascertain and point out, fellows, the effect of being a rowdy when it comes to your bail said anticipate.
That I wanted to know.
Said finally, fellows, who judgment the not who judgment where one of the factors considered is whether it is in the. So there are two judgments, fellows, bail, well, the aspect of bail is being considered.
Yes.
This aspect of him being the rowdy list.
Yes. Yes.
So paragraph.
Yes, we look into.
Yes. And one they seek for cancellation
on that basis.
On the ground that his name appears in the rowdy list, which court rightly declined. They dismissed the petition of cancellation of bail.
No, was it for cancellation that he was a rowdy sheeter? Was it one of the considerations?
It was an argument advanced, but
court said.
Court did not accept it, but rejects that petition for cancellation and ensures that the bail is there.
No, did it treat that he was a rowdy sheeter?
No, it did.
Then now that then they are not useful.
One matter, other two matters, when we are arguing for bail, the respondent would say is a rowdy sheeter. Please consider that as a factor not granting bail.
What the court said?
No, court granted bail, but they do take it as one of the considerations.
Treated. Then what is other? You back that one. Then it's not useful. I wanted to know. I wanted to know in criminal jurisprudence, a person is rowdy sheeted. Can it be urged by the prosecution to oppose the grant of bail? That was my question. How standard books are treated this aspect?
For that, page 6 for a minute, paragraph 5.
They have urged it true. I am asking you whether court treated it. They will say so many stories to your satisfaction. We go on writing that. Though I do not do that. See, that is not the question. In criminal jurisprudence, bail jurisprudence, any standard book, any writer saying rowdy sheeting can be considered as one of the grounds for granting, not granting.
In criminal jurisprudence, only aspect that is the antecedent.
In deciding that only I am asking. In deciding antecedents, whether rowdy sheeting figures as an antecedent.
No, in the orders, we do not get that as a consideration, but definitely in the objections, it is one of the factors.
They will take so many things in objections that may not be, but I wanted to know whether it is argued and acted upon. He is rowdy sheeted is also one of the grounds why I reject these things. One sentence per come. Learned senior advocate, Mr. So-and-so, appearing for the petitioner, when confronted with the question whether rowdy sheeting figures as one of the considerations in deciding the antecedents of the accused in bail jurisdiction, He says that although there is no, to his knowledge, there is no judgment which treats rowdy sheeting as one of the factors, comma, such grounds are urged by the prosecution almost invariably. First, in support of his contention, he banks upon three decisions.
I think one decision when they're passing the order also, they say the nature of offense committed by this petitioner and the fact that he was a rowdy sheeter, though criminal cases ended in acquittal and in which charge sheet is not filed, but the facts and materials placed before me in this case, I am not inclined to grant bail. Other factors.
The paragraph in it draws attention of the court to paragraph 9 in
the criminal petition number 468 of 2015.
468 of 2015. May I know? One second. I'll see that. Judge comes from the criminal side or? All. Wherein it is observed as a. Okay. Rowdy sheeting is the specific question, but you have argued like that. You means your predecessors in office. You are not answering your simple question. I wanted some Mr. Avasti, who has written best book on Indian Law Institute, Law of Bails. Not mentioned. I could not find such a thing in his book. Just look into Law of Bails nalli. Antecedent noduvaga idu baratta annod prashne. Adannu bittukondu ನೀವು ಎಲ್ಲ ಹೇಳ್ತಾ ಇದ್ದೀರಿ. Anyway.
I will look into whether in orders itself it reflects. I will look into that.
That is what. That's what. At least in very other countries nalli idru adil. He is a rowdy sheeter. Ali history sheeter criminal career antar bere kade. Criminal career criminal.
Yes, well, again, my lords have seen that those are cases actually like history sheetings have some criminal record and then you show it. But unlike here, my lords, where we say rowdy without having any cases against you also. That will be the subtle difference.
Correct. Even order 1059 of the manual differentiates between these two. Though in certain things it says will be mutatis mutandis applicable that way, but there is a subtle difference between these two. Yeah. Thank you. In rowdy sheeting matter, ಬೇರೆ ಕಡೆ ಬೇಕಾದಷ್ಟು ಚಾಣಕ್ಯ Supreme Court itself has said in half a dozen judgments. Yes. No, that is discussed in schools, colleges, parliaments. All correct. Rowdy sheeting is someone padange. But we have not enacted Chanakya Niti, Manusmriti in our laws. Niti Shastra. Niti Shastra, they have written. All right. Yes. That was a no. Latest, what subsequent to that? Because the Privy Council said where the enacted law is not guiding the court, they can go to Smriti Karas. 20, that Hanuman Pershad versus Masumat Babo, 1878 or 79 judgment. That's how that Mimamsa rules of interpretation. Yes.
Affidavit is filed in day methods. That affidavit is nothing but the statement of objections filed in my matter methods. They file the statement of objection containing the very same thing. I filed a rejoinder.
It will be in third person, and now it is posted said in first person.
Statement of objection and the affidavit I put through. I don't have to reply. My rejoinder is already there, my lords, and it is very apparent, my lords. Very apparent.
Let us.
2006 only. That was the last. And there was no annual reviews done at all. That was what was observed by this one. You're not doing your annual reviews. And without doing annual reviews, how are you keeping the name? Then I gave representation. It was a clear endorsement. No application of mine, why you should keep them. So this I wanted to bring to the notice of the court. Insofar as the affidavit is concerned.
The government AGA has filed affidavit in a so and so number so and so. He has also banked upon division bench judgment of Allahabad High Court, which at para 70 refers to Chanakya Niti. Chanakya Artha Shastra of Chanakya. And therefore, he wants to draw wisdom from that book. Okay. That is not your case in your statement of objections. You are only arguing. No. The result, heard and result.
He knows that if he finds a complaint, an inquiry will be held, this additional.
ಅದನ್ನ ನೀವು ಹೇಳಬೇಕಿತ್ತು. ನೀವು ನಿಮ್ಮ object statement ಅಲ್ಲಿ ಹೇಳಿದ್ರೆ I would have treated it, not now. You have already spent enough time on this matter. Heard and reserved for judgment. Okay. Thank you so much for your research and other things. Anything more to say? You have said. Anyway, I have already started framing that with the assistance of Mr. Faiz.
But all this happens with a lot of assistance from colleagues.
Otherwise, how to work? In fact, my strongest weapon in the armory is my Faiz and my staff members. All right, our Hesar Barkali. I enter Hesar Lakodi, so that I'll put their name here. Yes. I'll put their name. Okay. Thank you so much. Okay.
Previous matter.
Original bandada? Illi hakide original
Recorder munnalli irutte. Originals alla recorder munnalli. Recorder
hangare adನ್ನ change ಮಾಡೋಕೆ ಆಗ್ತದೆ. Even original is it matches with madam's version. ಅಲ್ಲಿ original is not there ಅಂತ ಹೇಳಿದ್ರಲ್ಲ. Original ಆ ಸೆಂಟೆನ್ಸ್ ತೆಗಿಬೇಕು. This original ಆಗ್ತದೆ. ಅದಿಲ್ಲ. Yes. Original adnu ಕಳಿಸಬೇಕು. Original seen and sent back. Yes. Inquiry early. Inquiry to be ordered because they have produced some other document. No? Head. Yes. Yes. Payments are made in crores in 2006.
Anita Abraham.
$150.
Also making the efforts to find out what I would like to ask the others. Because the study is 2006, at least they able to verify when these payments are actually made, because we didn't first immediately get all these payments.
Yes.
So 3 or 4 years ago.
Yes.
They say payments are made to Bharat Electronic with respect to certain dates. We cannot deny these payments. Payments are made. Platinum Realtors.
Correct. HSBC Platinum Realtors.
So now we are relating whether these payments made are relatable to 157. That is all.
No, even if you ignore 157, since you admit these payments, where is your case for calling for explanation of particulars of these?
So far as 161 is Platinum Realtors is a company which has been owned according to the things. So I have no agreement. This arbitration agreement with the CCPL folks has no Platinum Realtors in the picture. That's why if they give us these dates, I'll be able to verify. There was one see, it was a party to this agreement where they seek this arbitration. It was a tripartite agreement. Anunsi was there. That Anunsi is not any payment. Platinum Realtors has made some international debits. But Platinum Realtors is not in existence. If they at least give us these dates, I'll be able to verify.
This amount is received by whom? How you are related to this one?
I became the director of Bharat in the year 2020. I became, so I don't have clear knowledge of the earlier affairs, but as a company, I will be involved. That's a different issue.
That's fine.
As a company, but at least if I get the dates on which they provide that much information, I cross verify and come back.
Yes.
Because keeping other things issues open. As long as
You were asked to give over details of the bank. Other day I made some order. You had said that you will produce on your own.
Mr. Siddharth Yadav.
So in that I have seen that only in their application they have said that way. But if we go through the pleadings, it gives an impression exactly contrary to what they have said, that it makes no difference. I don't agree with your contention in that. Application but anyway, you should have accounted for. Yes, sir, Mr. Yadav. Yes. now come to page 161 of your petition.
Am I audible to my lord?
61 or 361? 161. 157 and 161. Your friend, Mr. Vivek Reddy, wants full particulars of this.
Full particulars of what? His bank statement.
Yes.
His bank, my lord, I don't have his bank statement. What had happened, is he trying to shift the ball into my court by claiming that this is not his bank statement? Let him say so on affidavit.
This is your bank statement, he's saying.
Put it on affidavit, it is not.
Huh?
Let him put it on affidavit. Let him put it on affidavit that this is not his bank statement.
Correct. This if you find out, you can find out from your bank order only. During what period this remittance was made?
2006. The dates are there. The dates are there. Yes, the dates are there on that state. PC 161. PC 161.
No, brother. If you ask your banker to give the statement for this period, 1 year earlier, 1 year next, you entrust it to some BCom graduate. He will say whether these are the amounts which you have received or not. He cannot. Kindly come to page 157. See the third column. Given dates are given. All dates are given. Huh? Yes. Yes. That is the date. The date of remittance is given. Each of them date has given. Please come to 157 now. There are 4 tables. On the left hand side, the largest table. Kindly see the names. Kindly see the dates. Amount paid. Yes. Come to the second table. Correct. Now, if you ask your banker for the said period, he said 2006. All these particulars will be available because the facts that lie within, especially within the knowledge of the party, the presumption is it is only you who has to say. Can you give dates of the first table?
My lord, please.
First table at 157.
Yes. Now, my lord, this can I just explain what my lord put to my learned friend and they are shying away. Please see the second table. My lord, there are 3 tables. My lord, correctly, 4 tables there.
4 tables.
4 tables. There is amount remitted. Right hand side top table is amount remitted to Bharat Infratech. Correct? Right side small table. 3 entries. Right hand side small table, 3 entries. On the top, it's written amount remitted to Bharat Infratech. My lord sees that?
Yes.
Yes. Now, first date is 4/5/2006, 50 lakhs.
10/5.
10/5, 40 lakhs. 15/5.
15/5, 2 crore 35 lakh.
Correct. Now, please
3
come.
lakh 35,000.
Kindly come to page 161. Kindly come to page 161. I should be able to satisfy my lord these three entries from this chart. 161, my lord has?
Yes.
Now, this is from on the letterhead of Karur Vyasa Bank to the manager Bharat Infratech. Same company which I had shown the column. Now, please see rupee remittance received on various dates for current account with us. With reference to the above, we have got foreign inward rupee remittance for the current account with us on various dates as below. Please leave the first entry. See the second entry. 4/5/2006. 50 lakhs.
10/5.
Then second
15,
entry. Second
15/5.
entry. 15/5, 2 crore 35 lakhs. And then fourth entry, 10/5, 40 lakhs. Identical. Now, please let me complete.
No, those dates are available in this one only, 161. Yes. Go to the smallest table on the right hand side at page 157. You produce your bank statement. All these questions will be answered.
My lord, I have a request. I have a
Yes.
request. My lord, on the last occasion, took a very strong view that they are obviously made a wrong statement on oath. Now, today, even before my lord, in my lord's courts, they are making, according to me, in my respectful submission, a wrong statement. So let it come on affidavit, and I say so for a reason with the request. My lord sees 162. Please see 162. After 161, 162, my lord sees. This is an email. Please see the second email first. The second email from Reggie to pro@Bharat Infratech. My lord sees that. June 7th at 3:08 p.m.
We confirm having received.
No. Yes. This is in reply to my email. My email is, dear Ketan Sonali, please confirm receipt of funds of 35 lakhs. This was sent to Gold City's account. Can you also please
35 lakh 60,000 on 26/5/2006.
Next line is important. Can you please issue a receipt of Charu Sharma investment of 50 lakhs? I've shown a receipt of 50 lakhs to my lord. Please see their confirmation. Dear Reggie, we confirm receipt from 35 lakh 60,000 from Hong Kong and 50 lakhs with white checks so and so. So their email now today on oath they are making a wrong.
No, this is by which company? This is by
them. Respond number 1.
Gold Cities Bank.
No, this is them. Respond number 1. Right at the top. Right at the top. Sorry, right at the 162.
Second one is expert. But this is first respondent.
This is him. No, my lord.
No.
The email is
Gold
from
City.
respond number 1.
It's the first respondent.
Yes. Mr. Reddy represents.
That is first respondent. Then
it's his email.
Gold City is second respondent.
My lord, sorry. I need to clarify. My lord, I need to clarify. Mr. Reddy represents first respondent. My lord, please see the mail is from first respondent.
Mail is from first respondent.
Yes. 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 Right at the top. From.
Yush Sahni.
No. Kush Sahni is printed it.
Printed it.
From. It says just before. From Bharat Infratech.
From Bharat Infratech.
That's him. That's him.
No, first mail is about that you have admitted.
You've admitted 50 lakhs.
50 lakhs you have admitted.
Yes.
That's your this one. Yes. That's all right. The first one you have already received. Have you disputed this authenticity of this document in your statement of objection?
Yes. Yes.
Yes, sir. No. Yeah, see, we have to draw some presumption under 114 of the Evidence Act, having regard being had to common course of event, human nature. These things are mentioned there. You have admitted the receipt of 50 lakhs, at least 35 lakhs 60,000. This is an admission.
No, my lord, can I show one more thing?
1 second. That's it. Yes. ನಿಮ್ಮ ಬ್ಯಾಂಕ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
My lord, can I make one submission?
1 second, sir. 1 second. No, you can't say that because company is always a perpetual. This is what we have been taught in Solomon versus Solomon. No, that may not. That contention is not available to a director. This is how Justice Kumar has held. Such a contention cannot be taken by a company's new director. It's a perpetual entity. New, all right, let us see. I'll do that. But that ಅದನ್ನ ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ. ನೀವೇ ಇರಬೇಕು ಅಂತಿಲ್ಲ ಡೈರೆಕ್ಟರ್. See, company is a perpetual entity. It does not die, even if all the shareholders die. Therefore, ask your banker, give a full statement. Yes. But that contention I cannot read because I am section 11 code. Yes. Before arbitrator you can. Even then that question stares at you. What if you want to produce material? Well, because such a contention in company law, in Palmer's company law, such a contention is rejected by the English courts, and that is followed by Justice Kumar in Karnataka leaching versus so and so. The arbitration agreement can be inferred by the transactions.
It's one I don't see who has not paid anything. But there are some cases that certain monies are paid. We don't know whether those certain monies
What I say is, instead of my making some observations which should not influence the decision making by the arbitrator, the best way is get some good arbitrator. Go for arbitration. I will keep open all contentions. We do not know. That may be available to you. We do not know. It may be time barred also, we do not know. But whether it is time barred or not is a mixed question of law and facts, which generally section 11 court will not entertain, except one decision of the apex court where it is so apparent. Then court said, no, I have examined it. In fact, I have spent a lot of time with this file. Yeah. No, they have said that it's not with them. Though in that application, very vaguely they have stated that this, no, that we cannot take that. Next date, finally, it is for you to, this one now, case is heavily loaded against you. I am making it clear to you. Because I should not make some observations. Yes.
May I make one submission? My lord, put to my learned friend, what is there? Please see their reply for a moment, para 25. Reply para 25.
Para 25 of?
Their reply before my lord in the section 11 petition. I have shown my lord their email. This is respondent number one.
Not
no.
rejoinder. Rejoinder.
Reply. Their reply. Their reply. Their reply before my lord.
Reply date. Can you give the date when it was filed?
Yes, my lord. I will. They filed their reply before my lord.
Objection.
7th October, I think.
Statement of objection of respondent number 1. Statement of objection.
Yes.
Page
Para
11, para 25. Statement of objection. Paragraph 25. That'll be page 11 at the top.
Read para 25 or statement of objections. I am not getting it here.
Denying the total agreement. The agreement is denied. Taken up this.
My lord has para 25?
25.
25.
It's a case of denial.
So, my lord had put to my learned friend that your email confirms receipt, but you are denying. And para 29 again. So, their email confirms receipt. In their email, respond number 1 confirms receipt. Whereas here, before my lord, in 25 and then 29, they deny it. So
the doubt arises as to his conduct itself.
As to his conduct itself. And repeat, that's why I'm requesting.
Is another thing. But this you could have admitted. No, you don't mention anything about the agreement in para 25. It is a pure transaction of money. No, that can be argued anything.
Hello, my learned friend is arguing contrary to his record.
The issue was that they should produce the original, and they should produce the original back with them. That is not
with whom the originals are now.
My lord had put to me this, that last statement is the correct statement. So I check, my lord, my rejoinder IA number 1, I've categorically said that their originals are with them, and for the reason why. My lord, I'll explain. My lord, they are based in Bangalore. Investors are based all over the world. They said they require originals for purposes of seeking permissions from the land registry department. In fact, pursuant to that, basis these documents, they executed a registered document joint development agreement. It is basis that these documents, they kept the originals because they needed to show to the registry department.
Where is that joint development agreement?
Please, joint development agreement is a registered document before my lord.
Yes.
Yes, kindly have Annexure J, page 221. So today to turn around and say everything is wrong, just it suits their convenience after receiving the money.
This joint development agreement is executed by you based upon those documents. Whether it refers to those documents here?
No, it does not.
It does not refer.
But it makes one very important, very, very important. Please come to page 244.
Yes.
My lord sees this is a document registered at the sub-registrar's office. On the left-hand side, my lord sees 2 witnesses.
Yes.
First witness is Hanut Singh. Now, who's this Hanut Singh? Hanut Singh is petitioner number 2 who has filed all the petition, executed the joint venture agreement with them. Everything has been done by Hanut Singh with them. The email which I showed to my lord from them is from Hanut Singh. The joint venture agreement is with Hanut Singh.
He's respondent number 1.
Petitioner number 2.
Petitioner number 1.
Petitioner number 2.
Anuj Singh.
And he is the lead investor in the joint venture agreement, page 186, page 164. Typed copy, my lord, will find at page 186. Please come to 186.
Bharat Infra, Gold City.
No, 186.
No, that's 186.
The joint venture agreement which they are denying. Anuj Singh. Bharat Infratech, Anuj Singh.
Yes.
And he, please read further with me. Anuj, this is Bharat Infratech, and Anuj Singh, resident of so-and-so, has been hereinafter referred to as investor, unless repugnant to, and Gold City. Now, please read further. Bharat Infratech has been referred to as BITPL, page 187. Yes. Whereas BITPL is in the business of developing real estate projects, including residential and commercial complexes, townships, hotels, and service apartments. Whereas Bharat Infratech is presently an absolute owner and title in possession and employment of properties located Municipal 10, so-and-so, measuring 14922 square feet, situated so-and-so. Next, and whereas BITPL proposes to develop this scheduled property into service apartments complex, commercial complex as per plans. Whereas Anuj Singh and his associates hereinafter collectively refer to the investors interested to venture into
the real estate market,
including hotels and service residential, have offered to purchase 49% in scheduled property and thereafter develop and run these service apartments jointly with BITPL, and BITPL has agreed to accept the offer of terms of
others need not wait. Some heavy matter it is. I have to dispose. Yes.
Whereas parties agreed to collaborate with one another in accordance with the terms thereof and for the purposes to operate through instrumentality of a joint venture company incorporated under the Companies Act under the name Gold City Builders and Developers Bangalore, which is respondent number 2. So Anuj Singh is the same person who is this attesting witness in their joint development agreement, which they admit. Joint development agreement they admit, and subsequently they have cancelled it. Behind my back, they have gone and cancelled it. Now, Anuj Singh, please read further with me at page 188. My lord has 188?
Yes.
And whereas BITPL will enter into a joint development agreement. So there is a mention of the JDA clearly here.
A development project wherein the JVC shall have 90% of right, title, etc.
And BITPL will have retained 10% in the project. Whereas the parties have mutually agreed to consider the value of the scheduled property at 16 crore 33 lakh. A, investors shall contribute an amount of 8 crore in the JVC, which amount shall be paid by JVC to BITPL, and JVC shall allot equity shares of rupees 6 crore 70 lakhs to BITPL, equivalent to 41% shares in the JVC towards sale consideration for the value of
land.
In terms of the JDA. JDA is the Joint Development Agreement. Simultaneously, JVC shall allot equity shares of rupees 8 crore to the investors, which is in Anuj Singh and others, equivalent to 49% shares. BITPL shall get 10% right title interest in the developed project. In terms of the JDA, in consideration of which BITPL shall surrender the 10% share and shall allot equity shares of 1 crore 63 lakhs in the JVC equivalent to 10%. The ratio of the share allotted in the JVC company will be 51% to 49% in the first party and investors respectively. Now kindly come to page 191. My lord has page 191, yes. Article 2.
Yes, objections of the JVC.
Sorry, it's a mistype. It's objects of the JVC.
Objectives of the JVC. Maybe.
Objectives of the JVC. Correct. Absolutely correct. The JVC main object shall be setting up an international quality service apartments project commercial complex in Bangalore as per plan approved and other.
This is cancelled on which date?
This is
Cancelled on which date?
Oh, please let me show that. They have filed that with their reply. Kindly come to their reply, their objections, which my lord was. Kindly, my lord, may I show? So cause of action, limitation. My learned friend was arguing limitation that goes against him. Please see their statement of objections, my lord.
Anyway, I will hear, I understood the case by and large. He wants to produce certain documents for his satisfaction. Anyway, I appear to be convinced myself to some extent. Now he wants to dispel that conviction of mine. Let us see.
My lord, may I just make one request? My lord had only make a noting. I'm not troubling my lord. My lord put to me JDA. JDA is filed with their statement of objection, Annexure B. It is cancelled on 17 December 2018 at Bangalore.
17 December 2018. 17/12/2018.
Yes.
Seventh of all. 8 division bench. 7th. Okay. 7.
I have filed my petition, section 9, in March 2020. So therefore it is within, when they commenced, and my lord, section 9 order, which holds good, they have not challenged it. They have not, so therefore that holds good. That clearly records that they have played mischief with the court. They have tried to circumvent the procedure, and they have received money. After that, they are trying to wriggle out. That finding stands.
Mr. Yadav, only in such complicated matters alone he is engaged. Your friend is briefed only in such complex matters, not ordinary matters at all.
I need not say more. I need not say more.
8ನೇ ತಾರೀಕು ಮಾಡಿ 7ನೇ ತಾರೀಕು ಮಾಡಿ.
Any short date, my lord will consider?
7th of April.
Can I make one request?
Yes.
Can my lord again have it at 2:30 only if convenient?
Yes, very well. 2:30.
And my lord, they will put in on affidavit. Let them put an affidavit with the bank statement.
No, perhaps he may convince his client himself. Where is the need for affidavit? He is vociferous fighter, yes, but he stands on the side of the justice even after all arguments. That is his nature. Even his father was like that only. Now he does not, very rarely comes to court only when occasion arises. Right. Perhaps now he is not coming.
Lord, I'm so privileged to appear before this honorable court. It's my pleasure and honor. Thank you. Thank you very much.
Mr. Jadhav, wait ಮಾಡ್ತಾ ಇದ್ರಿ. Mr. Jadhav, unmute.
I'm sorry, but I am appearing for my case in serial number 54.
54.
1 month.
7th of April. ಅದು 7th of April ಇಟ್ಕೊಂಡಾರೆ.
Not only you will also say finally, because this matter is being adjourned in instance of the other side many times.
They were also ready here. In fact, 7th of April. 7th of April. But 7th of April, ಎಷ್ಟು matters?
Finally, my lord.
ಬೇರೆ matters, but ಇವೆಲ್ಲ here ಮಾಡಿದ್ದೇನೆ. Okay. All right. Finally. All right.
Finally, please, my lord.
All right. Ramesh.
Yes, number 48. So dismissal ಗೆ ಅಂತ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ ಅದನ್ನ?
2012 matter. They were here actually.
Mr. M. Adinarayana.
Adinarayana has not come. But ಏನಂತ ಬರ್ದೇನು ಆರ್ಡರ್ ನಲ್ಲಿ? Ramesh is here. Yes. ಅಲ್ಲಿ ಅವ್ರು ಯಾರಿದ್ದಾರೆ ಅಪಿಯರ್ ಆಗ್ಯಾರ ಪಿಟಿಷನರ್ ಕಡೆ ಯಾರು ಬಂದಾರ? ಮೊದಲು ಅಬ್ಸೆಂಟ್ ಇದೆಯಾ? Counsel for the petitioner is absent. Though yesterday's order was as under, did not call this matter tomorrow for possible dismissal. ಒಂದು ಎರಡು ಮೂರು ಸರಿ ಮಾಡಿದ್ರೆ ಮುಂದೆ ಅದು ಉಳಿತದೆ. ಆರ್ಡರ್ ಇಲ್ಲ ಬಂದು ರಿಕಾಲ್ ಮಾಡಿಬಿಡ್ತಾರೆ. ಆ ರೀತಿ ಮಾಡೋಣ. ಓಕೆ.
But we'll be happy, Milad. Milad, by the way, your lordship wanted that decision, Milad, regarding the recent decisions of our High Court, Milad. One is 2019 ACC Online Karnataka 511.
2019
ACC Online Karnataka 511. Ganesh versus State of Karnataka.
This we have.
And then another is 2021 ACC Online Karnataka 11987. Gurumurthy versus State of Karnataka.
Page number?
Page number 11987. 11987.
Oh, Karnataka.
Karnataka means SCC Online birthday. 5 digits birthday.
Thank you. Thank you so much.
No, it's my duty, Minister. I'll be of some help, Minister. In both the cases, the issue was considered, Minister.
Yes, sir.
There is an advantage of being present in the court, Minister, even through VCR.
That I should have told you. That is the advantage of presence, your presence in the court.
No,
ಪುಟ್ಟೇಗೌಡರು ಹುಷಾರಿಲ್ಲ ಅಂತ ಇವತ್ತು ನಾವು ಟೆಂಪಲ್ ಇದಕ್ಕೆ ಹಾಸ್ಪಿಟಲ್ಗೆ ಹೊಟ್ಟೆ ನಿಂತ ಹೇಳಿ ಎಲ್ಲ ಕೊಟ್ಟಂಗಿದೆ ಡೇಟ್ ಆಲ್ರೆಡಿ 2 weeks ಕೊಟ್ಟಿದೆ. ಇಲ್ಲ ಬರ್ದಾಗಿದೆ ಆಲ್ರೆಡಿ ಇಲ್ಲ.
Officer, serial number 61. Hello. Court officer, sir.
Sir, 61, 2 weeks, sir. Not reached 2 weeks.
Not okay. Thank you, sir.
Sir, 57, sir.
Huh?
57, 57.
5-7, 2 weeks, sir.
Okay, thank you, sir.
ನಿಮ್ಗೆ ಗೊತ್ತಾಗ್ಬೇಕು ಸುಮ್ಮನೆ ನೀವು ತಲೆಗೆ ಬಂದಾಗ ಇರೋದು ಹೇಳ್ಬೋದು ಅರ್ಥ ಮಾಡ್ಕೊಂಡು ಮಾಡಿಲ್ಲ ಅಂತ ಗೊತ್ತಾಗಲ್ಲ ಯಾರು ನಮಗೆ ಹೋಗೋದನ್ನ ರಿಸೀವ್ ಆಗಿಲ್ಲ ಅಂತಂದ್ರೆ ನಮ್ದು ಕೊಡೋದು ನಾನು ಅಲ್ಲಿ ಸೈನ್ ಆಗಿರ್ತೀನಿ ನಾವು ಎಮ್ಮ ಬಂದಿರೋದು ರೆಕಾರ್ಡ್ ಬಂದಿದ್ದು ಆಮೇಲೆ ರೆಕಾರ್ಡ್ ಹುಟ್ಟಿದ್ದು ಕೊಟ್ಟರೆ ಅವೆಲ್ಲ ಲೇಡೀಸ್ ಬ್ಯಾಂಕ್ ಇಟ್ಕೊಂಡು ಹೋಗ್ಕೊಳ್ಳಿ ಅಲ್ಲ ನಾನು ನಮ್ಮ ಬುಕ್ಕಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ಕೊಂಡು ಫೈಲ್ ಬಂತ ಸರ್ ಈ ಫೈಲ್ ಬಂತಾ ಯಾರು ಹೊಸನ ಫೋನ್ ಮಾಡಿ ಹೊಸನ ಫೋನ್ ಮಾಡಿ ಫೋರ್ಜರಿ ಆಗಿದೆ